Yes, yes,
My lord, may I have your lordship indulgence to mention item number 21?
21.
So we are to file an affidavit in reply. So I pray for 4 weeks time. 4 weeks time.
You are going to file an affidavit in reply?
In my,
Okay. Mr. A.C. Borgohain, the learned senior counsel, appearing for the petitioner, submits that they would like to, he would like to file an affidavit in reply to the affidavit in opposition filed by the respondent. He prays for 2 week, he prays for 4 weeks time. Prayer is allowed. Let the matter be listed after 4 weeks.
May I please, your lordship? With the consent of the other party, I beg to mention item number 23 of the supply list, your lordship. Lordship, the learned counsel, Mr. P. Naik, is indisposed today, your lordship.
No, it's a part-heard matter.
Indisposed today.
Part-heard matter cannot be given adjournment like that. You have spoken to the other side.
Yes, your lordship.
So, but then I'll have to release this matter from part-heard. It has been kept part-heard for, it has been heard twice. Twice it has been heard. When he will be available?
Next week, any day, your lordship.
My lord, after 2 weeks, my lord, next week, NNB photo is not available.
No, it cannot be kept like this. I mean, it cannot be kept like this. Next week, some date you give me. You consult with NNB Chaudhary and let us know. Let the court master know. Next week we are going to fix it. We cannot keep it. I mean, this matter has been heard twice. 2 times it has been heard. It has been, I mean, on the request of the parties, it has been kept part heard. Now you are mentioning it, and both of you. You consult with Mr. NNB Chaudhary and we'll fix it. We'll fix a date. You decide a date on next week. So we'll take it up. Otherwise, we'll release this matter from part. You let the court master know. You talk with Mr. NNB Chaudhary and let us.
Your lordship, in regard to the item number 19 of the daily list, lordship.
Item number 19.
19.
Yes.
I've informed the other side, lordship. I'm praying for adjournment for the day, lordship.
What is this IA for?
Lordship, actually this I is for drawal of perjury against the charge of perjury against the contemners. In this I only, lordship, some hearing needs to be
Required.
And
Who is appearing?
Mr. S. Datta, senior advocate, he will be leading me in this case, lordship. Today he has some difficulty, he could not come to court, that's why.
Okay. On the prayer of MS so-and-so. Which is not objected by the counsel appearing for the other side. Let the matter be listed after 2 weeks.
2 weeks, ma'am?
After 3 weeks.
Deeply obliged.
Yes.
Back is my lord, in this case, police case diary pertaining to.
You have filed an affidavit.
My lord, we have already filed our.
Yeah, but affidavit, I mean, what have you stated here? I mean.
My lord, we have stated that it is a normal policy of the army to maintain the record.
No, you have stated something which is little bit, I mean, difficult to consume.
What?
Para 6 of your affidavit.
Para 6, my lord.
However, the petitioner in this paragraph has admitted that Probit Nazari is an extremist.
The extremist, my lord, may kindly.
Where they have admitted?
My lord, may kindly come to.
Yes, it's good, sir.
You have to refer to para 2.
Para number 2, my lord.
Yeah, para number 2, you read what have been stated there.
In the instant case being filed by the petitioner, petitioner number 1, Anjali Narzari, who is the wife, and petitioner number 2, Miss Mohima Narzari, is the daughter of the extremist victim, my lord.
Daughter of the extremist victim.
Yes, my lord.
Is he an extremist?
No, my lord.
Then why you have written extremist?
My lord,
In affidavit, you have stated that you have declared him an extremist.
no, my lord.
The
that is-
person doesn't have any antecedents of any extremism.
My lord, actually, that is
No,
not.
no, why have written this?
I'm extremely sorry, my lord.
And like
my
when
apologies.
this court was asking you, then you were saying you are referring to a clause, and I mean, this is a very clear, I mean, there is nowhere it has been mentioned. Why they will admit that he's an extremist? They have come for extremist death compensation,
Yes.
correct? Then you have made him the extremist. But Mr. Mannan, how you are going to get any relief in this matter?
My lord,
See, is there any evidence? Is there any evidence showing that he has been killed by any extremist?
my lord,
Is there any report?
my submission before your lordship, my lord. He was a school teacher, my lord.
Understood.
Suddenly he was picked up from house.
All understood. He has been taken away by the
Madam.
army for interrogation. That after that, army's version is that he has been released. But you are saying that he is missing from that point of
From
time.
that day.
But
he is
how you can file a petition after 15 years and asking for a relief under extremist death?
Your lordship kindly
Due to-
see, my lord, my incident took place 30/8/2021.
Correct?
And FR submitted 30/9/2009, my lord.
Then what have you been doing for last 15 years?
My lord, my death certificate I have obtained 2015, and after obtaining death certificate.
Why you
and-
have obtained a death certificate after 15 years? What is the mandatory
My lord,
period?
My lord,
What is the statute? What does statute say? If somebody is missing, after how many years you can get a death certificate?
in the meantime, my lord, I approached the, my lord, authority concerned, my lord. My lord,
No, yeah, but where is your document you have approached? You have approached only when the person was missing, at that point of time only. But you are seeking a relief under this notification, right?
my lord, my application, my lord, page 28, my lord. With all respect, my lord, page 28, my lord, annexure 8, my lord, of the writ petition. I have filed an application, my lord, in 2015, my lord. Please, my lord, page 28. My lord,
Now, what do you want? Yeah, is it your case that like army has done some mischief? Or is it a case that like he has been killed by
Your
extremists?
lordship kindly consider a person, an innocent person.
Understood. But you have to make out a case, mister.
My lord, a
You'll have to
person
make
has
see
been
if you want to come under that notification, then you have to make out a case that he has been killed by extremists. Where is the report?
My
Where
lord,
is the report?
My lord, with all respect, my lord, a person has been picked up, my lord.
I understood.
It was the duty of the army personnel to leave the person in his home where from he was picked up, my lord. My
From
lord,
a-
in a evening hour, my lord, he has-
a matured person, he has been asked to come, he has been taken away. It's understood he has been taken away by the army. We understand, we have all, the court also has that empathy with you, that the person is missing. But only thing is that if an adult person has been taken away, then
Without any reason.
he was interrogated. Then as per the police report, he has been released by the army.
There is
Then
no
after-
document at all, my lord.
Listen, he has been released by the army. Now you are saying you are not sure whether army has done some mischief or extremist has done something. If army has done some mischief, then he'll have to plead the case accordingly. Then he'll have to, he'll have to plead the case accordingly and say that the army is responsible for this. You have not stated so. You are in two minds. Whether he says, army is responsible or extremist has killed him. And you are praying for the relief under the extremist death.
Sir, my submission before your lordship, my lord, if a person has been missing, my lord, since that day, my lord. My lord, if my lord, any case was registered against him, that is another thing, my lord. No case, nothing, my lord. Innocent person, he is a amazed.
No, you'll have to convince this court that you come under this relief, whatever the relief legislation or this is a notification, right?
Yes, my lord.
No, the government notification, that you come under that.
Yes, my lord.
Otherwise, how can this court can give you relief?
My lord, in this respect, my lord, I have some citation also, my lord.
What
Earlier
citation?
occasion, my lord, court, my lord, asked for some citation, my lord, I have collected.
Okay, place it before
My
this
lord,
court.
before my learned senior placed this judgment, I would like to point out just one thing. My lord, incident occurred on 30/8/2011. and 15 years they have done nothing. Thereafter, my lord,
No level.
FIR has been lost after 9 days.
21.
FIR has been lost after 9 or 10 days, and the case has been registered only under section 343. That amounts to wrongful confinement. And final report in this instant case has been submitted, if I'm not making mistake, my lord, that is, final report was submitted maybe on 35/2009.
Have you done any inquiry?
My
Yes, sir.
lord,
Have you done any inquiry? Army has done any inquiry?
Sorry? We have not done any.
Why?
inquiry, my lord. Because it is the responsibility of the police to undertake an investigation. When the FIR has been lost.
You have taken him away. What has happened to him? The allegation is that after you have taken him away,
Yes, my lord.
he is missing. So
I don't-
whether you have done any, is there any effort from your side to find out exactly what has happened?
My
Is army not responsible if army has taken away?
We our own did not hold any kind of inquiry, but we have cooperated with the police, my lord, local police, before whom this FIR has been.
Where is the evidence that he has signed some document?
My lord, that particular document, according to army, that has been submitted to the police, my lord. That is why case diary of police case pertaining.
You don't
to-
have any record?
My lord, we ourselves do not have any.
Why?
records.
This is a signed document with you.
My lord, that
Why you have delivered it to police without having a copy, keeping a copy with you?
My lord,
That-
copy might have been there, my lord. This is a case. that
Might
has
have been
filed.
there, then placed before the court. What might have been
No, no,
there?
But there is a policy from
What
the army
policy?
side
Hmm.
that normally beyond 10 years, we do not keep any record, my lord. We used to destroy it, my lord. There is a time limit
Hmm.
to which we keep our record.
Hmm. So you have destroyed it.
Thereafter, my lord, and that particular office order that I have specifically annexed in my affidavit. My
What officer?
lord, may kindly come to page 39.
Yes.
इसको क्या बोलता है?
This is your policy of
This is
retention
the
of
policy.
documents.
These are the rules, my lord.
Hmm.
And according to these rules, my lord, may kindly come to page 40,
What is this rule?
my lord.
What is this rule?
My lord, there is a policy in the.
No, what is this rule? What is this rule? I mean, what have you annexed? You have annexed certain pages from some document.
Yes.
So what is this document? I do not know.
Deeply obliged. Then, my lord, I may be.
No. You tell me why this has been annexed like this? Why it has been annexed like this? And certain pages cannot be read also.
That's why, my lord, in earlier occasion, my lord, some documents were sought for from the court, my lord. They are directed, my lord, to produce some document. My lord, in earlier order, my lord, it has been reflected.
My lord, in the earlier order, state has been directed
It was directed, my lord.
to bring the record of the.
Who is appearing for this? What has happened to this document? There is a proof that you have submitted a report saying that there is a proof that he has left that army, custody of army hale and healthy.
Out, my lord, due to that bifurcation of district, my lord, Nonbury and.
But that cannot be an excuse.
But so far.
A
as some-
person is missing, that cannot be an excuse.
Lordship, they have tried base, my lord, but so far as my communication, kindly see the annexer, my lord, to my second page. They have reported from the ZT, some ZD entry was there, my lord, regarding that FR report, and that has been.
The FR report, I have seen it. We
PSK's diary, Lordship, 133/2001, Tamuspur PSK's, my lord. That record could not be traced out in spite of their rigorous search in 3 districts, my lord.
there is a specific mention that there is a proof that he was released on so and so at 5 evening. Where is the proof?
Without that record,
But anyways, I mean, where this petition is not maintainable. How can it be maintainable? How can you seek a relief under the extremist death? Relief.
My submission.
You go to the civil court, you go to the civil court, claim for damages, but red court cannot.
It is only responsible, army responsible, my lord. My lord, since the person has been. taken away,
And,
my lord, without any reason, my lord. Without any reason, my lord. My lord, I think, my lord, army is responsible, my lord. A innocent person, there is.
So what is your case you have filed? You have filed for compensation. Army is responsible, you are seeking from whom? If you are asking for army, then you'll have to modify, you'll have to withdraw this petition and file it again.
My lord, in my their portion.
You are,
of
you
the
are,
policy,
you are
either-
seeking a relief of ex gratia. Ex gratia because of the death of unknown extremist who presumed to be killed by unknown extremist. That is your case.
my lord,
Can you presume to be killed by extremist?
after my lord incident.
You tell me one thing. Can you presume that he is killed by extremist without having any evidence? This is your prayer.
Lord,
You have filed this petition with the presumption that he has been killed. After he has been left by army, he has been killed by the extremists. Is there any report? If there is no report, how this court will entertain this petition?
My lord, immediately after the incident, I filed an FIR, my lord. That
You
was
tell
registered,
me,
my lord.
the police
And,
has given an FIR. The police report is very clear that there is no angle, there is nothing, no whisper about any extremist doing anything, any role of extremists killing him. So how can you presume it?
In the FIR, my
No, no,
lord.
you tell me, you convince me. I mean, I'm ready to hear your arguments. I'm ready to hear things. We have all sympathies with the family. We have all sympathies with the family, but
But-
you tell me
My
whether
lord,
this petition can be entertained.
FIR has been accepted by the informant.
My lord, page,
Accepted by,
page 20.
Informant.
Who?
that is Northern Nigeria, informant.
Informant.
My lord,
FIR has
page-
been
page
accepted.
The
21,
father of the deceased, my lord.
Where is that?
page 20.
Instruction, my lord, page 1. Today I have case some. Instruction dated 17/4/2026.
17/4?
2026. Doctor C reproduce annexure to that instruction, my lord, specifically stated by the SSP person.
Moreover, my lord, there is no challenge to the FIR, FIR that has been submitted to the court, my lord.
Which paragraph?
Third paragraph, my lord.
Third
Further
paragraph.
communication was made with PSI, that is a.
Mano, which page you are reading?
Annexure 2 to the.
Annexure 2.
Annexure.
That is a communication to SSP Baksa to SSP Ramanpur, my lord, dated 13/4/2026. Second para, my lord. Further communication was made with PSI Nonbari Court, and it was learned that the informant of the Gamely Nogan Archery had filed a petition before the court of SDGMS Nonbari, stating that he did not wish to proceed with the case and he had no objection to the final report. Accordingly, the final report was accepted as per records of the government registrar GR Nalbari on 21/10/2011.
So where is that? Where is that order?
That order, my lord, could not be traced out, my lord.
No, no, in the court of SDGM.
Yes, my lord, that one ZT entry, that is not very legible, but contents of the same is annexure 1 kindly perused, my lord. There is a mention regarding that GR entry, ZT entry, GR register entry, my lord. Second paragraph.
This is from CGM to officer in charge. Okay.
Because district were bifurcated, my lord. Initially it was in Nalbari, then Baksa, now it is in Tamil Pradesh. Entry in the GR register is mentioned in annexure 1. Communication dated 4/4/30. CGM was.
But how come this record is not there in SDGM normally?
They have tried out, my lord, tried their best, my lord. As on today, could not be traced out.
But the FR has been already accepted. And there is a statement that he did not wish to proceed with the case. And without otherwise also, I mean, under the extremist that whatever that notification is there, You could not make out any case out of that. There is no report, nothing.
File an FIR, my lord,
No,
that-
you filed an FIR, FR has been filed, and SDGM has, that concern SDGM has written that that has been already closed. FR has been accepted. You haven't challenged that. You have not objected to that. We'll have to dismiss this petition.
my lord, let it be come on next week, my lord, I will, my lord, provide any further, my lord, citation, my lord, I have.
Citation you give me, what is the, these are the citations.
Yes, ma'am.
These are on what?
My lord, the innocent person picked up by army personnel, my lord, and, my lord,
No,
forced-
your case is not custodial death.
not death, my lord, not cut.
Then
My lord, my submission before you lost.
all these petitions are
They are
habeas
saying-
corpus.
They are saying, my lord, he has been released. My lord, there is no proof. There is no proof at all, my lord, and. that
Is
proof
there any,
was-
is there any material with you that army has done something wrong? Have you alleged so?
My lord,
The
only
army
my
has
lord-
done something
only
wrong.
my lord, he was picked up without any reference, my lord, without any cash register.
There,
against-
army can pick up, I mean, you are not challenging that. I mean, you are not,
My lord,
army can pick up somebody
Huh?
for interrogation if there is some suspicion. Is there
my
any
lord, it
bar?
was the duty of the army personnel to leave him at his home, and the evening hour, how they can, my lord, live in the, my lord.
He's an adult person. He wants to live. He,
My lord,
after the
they are-
interrogation,
My lord, they are saying, my lord,
Mhm.
my lord, they are saying.
What you
my
are
lord-
saying?
My lord, they are saying, my lord,
You are saying that like he has been killed by extremist. You are not saying the
Maybe, my
army
lord.
has done something.
maybe, my lord.
Then how, what may be? If you are saying that like extremist has killed him, then there should be some material, no? You'll have to bring before this court.
Let it be come on next week, my lord. I will, my lord, first.
Next week, we are fixing it because it's a case where the unfortunate incident had
My
happened.
lord, unfortunately.
Only taking into consideration with taking into consideration that aspect,
My lord, my lord,
that this is an unfortunate incident happened. We'll fix it up in the next week.
Deeply
And
obliged.
you also try to, I mean, Burman,
Deeply obliged, my lord. We
if
shall
there
try-
is something you try to assist this court,
my lord,
because it's an unfortunate incident, whatever. I mean, we don't know who is responsible, but the incident has occurred. There is no dispute about that. The person is missing, he is gone.
My lord, only my lord, he, my lord, joined in service, my lord,
No,
19.
those things are
only
fine.
2
Those
years.
things, those things we know
My lord,
about this.
his wife and.
See, I mean, those things we know. I mean, don't try to, I mean, make submissions on those sympathetical things. You make out the case, then only this can be taken out.
At that particular point in time, there could have been a possibility of ascertaining the facts.
Their efforts should have been challenged at that point of time. That objections should have been done at the point of when you have come such a delayed after 15 years.
I leave you will be whole lordship, my lord. Let it be come on next week, my lord. I will.
Okay, on the right, heard Mr. A. Manaf, the learned counsel appearing for the petitioner, also heard Mr. Deka,
B. Deka.
B. Deka, the learned CGC, as well as M. Borman, the learned counsel for the state respondent. Let the matter be fixed in the next week. Let the matter be fixed on next week. You come up with something, some good material, otherwise this will be dismissed.
My instruction,
Yes.
My submission, my lord, some
You
consideration. my-
write, MS Bourbon, the learned junior government advocate, has submitted a communication dated 17/4/2026, along with certain, annexes, which is kept on record, marking X. Mr. Manaf, you come up with something, because your petition, I mean, you are seeking for relief under
Only-
Public law review.
only, my lord, some consideration, my-
relief of, under certain provision, but like that provision, I mean, that is not, I mean, you could not make out any case of. Oh, we'll see. This you want to keep it with yourself? Citations you keep
My
yourself,
lord.
Due to the
with yourself, then you can submit on the next date.
My lord, let it be fixed on, my lord, in first week of May, my lord, if possible, my lord. 13 or 15, my lord,
May.
Okay, let the matter be fixed on 13th,
my lord.
13th of May.
It's a old matter, my lord.
Hmm?
It's a old matter, my lord.
All matter, I mean, all matter, I be understand.
Obligation.
DP of that.
Have you applied for this?
Lordship,
Consent to operate.
No, Lordship, I am the complainant, Lordship.
I am on behalf of the respondent, I have already applied.
They,
Mr. Borwa, they have applied.
yes, my information says that they have applied, but because of the past election responsibilities, so that inspection couldn't be done. So ultimately, we'll pass the necessary orders as per the relevant provisions.
But in the affidavit, Lordship, the Pollution Control Board affidavit that the sound was higher than the normal.
So they will inspect it. They will inspect it, then they will, I mean, what, if they find it within the parameters, then they will
We
issue
will
the
allow,
certificate.
otherwise we may not.
They will issue the, so should we dispose it off?
Yes.
There's nothing here to
Lordship,
keep it pending.
let them give the report.
No,
Lordship,
I mean, the
Report
only thing is
already-
that like whether they have this,
the application.
No, if at all he's agree, we can very well approach, but for the moment, his prayer has been rejected.
right, heard Mr.
She Sharma, Lordship.
C. Sharma, the learned counsel for the petitioner, also heard Mr. S. Borwa, the learned standing counsel for Pollution Control Board Assam. And Mr. DC not for respondent number?
Aye.
Respondent number?
9.
Nine, respondent number 9. The instant petition has been filed by the petitioner alleging that the fabrication industry established by the respondent number 9 in the vicinity of the petitioner's residential premises is creating noise pollution, disturbing the neighborhood. Full stop. Next para, right? In this regard, in the instant case, an affidavit has been filed by by the Pollution Control Board. Pollution Control Board, wherein it has been stated that though the concerns unit, the concerned fabrication industry has been given a certificate to establish, however, the consent to establish, however, the consent to operate was yet to be given. In view of the aforesaid stand by the Pollution Control Board, this court has inquired whether the aforesaid fabrication industry has already applied for a consent to operate or not. So you have filed an affidavit? You haven't filed, but you have the instructions. When did you file it?
Applied phrase application, Lordship,
Give it to me.
online.
Then on a specific query made by this court, it has been submitted by the council appearing for respondent number 9, representing the aforesaid fabrication industry, has submitted that the fabrication industry has already applied for consent to establish before the Assam State Pollution Control Board. why it is application, why it is online application dated? Is there any date?
18/3,
18/3,
2026.
applied on 18/3. Where is the date? Is there mentioned?
That's not mentioned, but. Sorry.
In fact, previously on our inspection, we have asked them to apply within 15 days statutory period, like. So accordingly, they have applied within that period time.
Okay, you write it, 18/3/2026. 18/3/2026, full stop. The Learned Council, the Learned Standing Council for the Assam State Pollution Control Board has also confirmed that they have already applied for the consent to operate, full stop. In view of the submission of the aforesaid application, the Learned Council appearing for the Learned Council for the Pollution Control Board submits that due procedure will be followed and inspection will be done, and after such exercise, if it is found suitable, then the necessary consent to operate will be issued to them. Full stop. In view of the aforesaid submissions, this court is of the considered opinion that there is no point keeping this writ petition pending, and therefore the same is disposed of, with the direction that that necessary inspection shall be carried out within how much time will take?
That I cannot say at the moment, because ultimately we have to consider the application. So we'll inspect.
No, but there should be some time limit. I mean, you cannot keep it pending like that.
I think within
And
30
what is
30
your
days,
period?
within 30 days, we have to.
Is there any statutory period?
Static 30 days.
30 days. 30 days from
From the date of
their
application.
applications.
Yeah.
30 days already over, I think.
Over maybe.
See, they have filed it on 16/3, right?
No,
18/3.
18.
18/3. So it's already over.
I think because of the election
No,
responsibilities.
what pollution control is doing in election?
We'll do.
Will, after passing of this order, within 1 month,
Yes.
you dispose of their application, whatever. It is directed that the Pollution Control Board will do the necessary exercise of inspection, as well as uh, acceptance or rejection of the application of the respondent number 9 within a period of 1 month from passing of this order. Also, the instant writ petition, in view of the aforesaid directions, the instant writ petition is disposed of. So they will see the parameters. If they found it fine, then they will issue. Then after that also, if you have something, then you can come.
What is the matter related to the grant of installments under the PMAY-G scheme? If my learned friend has any instructions, sadly I could not contact my client, Your Lordship. So I'm not aware whether the last installment has been released or not. If my learned friend has any instructions, perhaps the writ petition may be closed, Your Lordships.
Yes.
Yes, my lord. Already 3 installments has been paid, my lord. Maybe already 3 installments has been made, my lord. Maybe because of that, not
Because
is
Your
not
Lordship, the
contacted.
person
You
with
could not
disability,
contact me.
90% visual impairment, he's unable to look at his phone also, Your Lordships.
Okay.
So we've been trying to contact him. We have not been able to do it. If my
Yes,
other
yes.
friend can perhaps place that document on record in view of
Is there-
that.
This is only photograph of the computer, my lord. But I can place the dates, my lord, on which date that was paid.
That will suffice?
Be okay, Your Lordships. Should be okay, I guess. Yes, Your Lordships. If he has the details will be given to the court, and in those terms, the.
You do one thing, you take a printout of this.
Yes, yes.
And like, please give it to the court
My
martial.
lord,
I'll
my
pass the order. I'll just close it.
Yes, Your
My
Lordship.
lord.
Close it.
That can be done.
We'll close it,
Lordships.
right?
My lord.
You just give the document,
Yes,
then
yes.
once we get the document, we'll
Yes,
just
yes.
close it. We'll
My lord.
dispose it off.
My lord.
Deeply obliged.
High level.
You take down the names, huh? Bindi, Archit Chaudhary and Is there any instruction? I mean, B. Gogoi,
There is some urgency from the bank side.
hmm,
Can I just place the facts, minus? Mr. Gogoi will be there. I
Mr.
think.
Gogoi is appearing?
Yes, Lordship. Lordship, he's on legs in court number one.
I
He has
just-
gone to the old High Court. But I have been directed to inform, let the other side continue. We will make notes and accordingly we'll make submissions on the next day.
Next date? No next date. You'll have to do it today only.
In that case, Lordship, can it be taken after some time?
No.
Because he's on legs in court number
No,
one.
you make your notes. I mean, when he comes, then he can join.
Lordship.
Let him submit whatever.
Lordship,
He can start. Senior
Lordship.
can start.
My lord, later, after 5 minutes, I'll give the list of dates.
1 second.
I'll.
Yes,
My lord, I'll just give the list of dates.
yes.
First, I'll just place what is about the case. Well, there are few gardens in the state of Assam, at least about 15 gardens which belong to ATCL, Assam Tea Corporation Limited.
Hmm.
Now, they could not run those gardens. The
Hmm.
gardens were in the bad shape.
Hmm,
So to revive those gardens,
hmm.
they decided to float an RFP so that it can be leased out to various leaseholders. So practically this matter pertains to one, they call it the packet, Sibsagar district. There are various districts. This pertains to a Sibsagar district. They call, there are two gardens, they say this is a packet, one packet.
So in Sibsagar district, two districts were involved.
No,
Two gardens were
two
involved.
gardens, they call it Sibsagar packet.
Sibsagar packet. Okay.
Packet. So there are two gardens,
So two gardens.
they decided to lease this particular two gardens.
Okay.
So these two gardens were leased
Hmm,
by way of an RFP.
hmm,
So the leaseholder,
Hmm.
my lord, he participated. And my lord, ultimately, they decided to give this garden to that leaseholder. But to run this garden, which was not in a good shape, they
Yeah,
have to
it was,
take a-
no, by RFP, it was leased.
Yes, it was leased.
By way of RFP, it was
RFP, they
leased.
participated.
So
If various
uh,
participant
so who is the
participated.
leaseholder?
So leaseholder is one
Respondent number?
7. We
7.
serve copy to them.
Hmm.
It is on record, but they are not appearing in this.
Nobody is appearing.
Yes, that has been served.
Okay, lease, so it was given to him.
Yes.
Hmm.
Now, my lord, to run this garden,
Hmm,
it was not in a good shape.
hmm.
So of course, they have to go to a financial institution for
So
this.
they need to invest some money there.
Yes.
Hmm.
Now they approached us,
Hmm.
the Punjab National Bank. I am representing the Punjab National Bank. They approached and they said that, yes, we want a financial help from you. Accordingly,
Hmm.
we decided to pump
Hmm.
2.4 crores as a term loan.
2.4 crores.
4 crores,
Hmm.
which is, my lord, you will kindly note, when you approach a bank, you have to give a margin money.
Hmm,
So margin money was 80 lakhs,
hmm.
or totally it became 3.2 lakhs. 3.2 crores.
Margin money is 80 lakhs.
80 lakhs. So totally it become 3.2 crores, right? If I'm not wrong.
No, margin money will be given by whom? By the leaseholder?
By the leaseholder.
By the leaseholder to
Yes.
you?
Normally it's a car also loan, a margin money is.
Correct, that has to be paid by
Yeah,
them.
2.4 crores the bank pumped in, but the margin money has to be given by the leaseholder.
Hmm,
So they paid 80
hmm,
lakhs.
hmm.
So 2.4 plus 80, if we plus in that 3.2 crores.
No, but, I mean, you have given 2.4 crores.
No, right, but
Hmm.
I'm just pointing out
total
margin
amount.
money, total amount
Huh.
is 80 lakhs the leaseholder has.
So 3.2 crores ultimately invested.
Yes, right. Leasehold premium is for a period of 30 years. Please note down, my lord. The leasehold period is for period of 30 years.
Okay, leasehold for 30 years period.
30 years.
Yes. So 3.2 crores invested in the garden, in
Yes.
these two gardens,
Yes.
and 2.4 crore was given by your bank,
Yes.
and
right.
80 lakhs was invested by them.
Correct.
Is a
This is
margin
the
money.
position.
Correct.
Now to run this garden,
Hmm.
it absolutely was not in a good condition.
Hmm.
Now that is why they have leased out.
Hmm.
So now, my lord, this 4 crores was given as a cash credit facilities to the leasehold. The leasehold,
4 crores
Four
as a
crores.
cash credit.
cash credit facilities
Facility.
was given.
Okay.
Yes, now, my lord, please note, I will show also. There was, once it was given to them, so all the formality which has to be done by the bank, it was done with the leaseholder. Your lordship has to note one point, it's very important, relevant. There is a lease between the ATCL and between leaseholder. Yes, see.
Hmm.
There was an agreement which was, the bank was not a part of it. And please note down that specifically mentioned by ATCL, the land will be with them. You don't have any right over the land.
It's a leasehold, so like, I mean, it will be with
So-
them.
Sorry?
So it was not
title-
mortgaged to you?
No, title of the land continues to be with the ATCL.
Hmm.
That your lordship will.
So
please
now,
note.
what were your security documents?
The security document was the investment which you made 4 crores.
Hmm.
And now your lordship knows, I will place it. That's why I'm saying there are two statute which is important. One statute, once I give the list of date, one statute will be the Surface Act and the next statute will be Transfer of Property Act.
Hmm.
These two statute, I like to draw your attention. What are the provision? How it is secured?
But
by
what
these
is the
two acts.
security that you have taken while giving the loan?
The lease deed was the security which you have, lease deed.
But lease deed, like lease deed
I-
will help you?
I will show
Because
it.
the land is already with them.
No, I will
ATCL.
show it. I'll show before. That's why I'm saying two statute is important. One is the statute under the Surface Act and another statute is under transfer of property, how it can be secured. Because this, your lordship, I have to show that how this money is being secured. We become a secured creditor. How
Correct.
we
That's why
become
I'm
a secured
asking, what is the
creditor.
security? Yes.
That's why I will show it, my lord, by
Mhm.
various statute.
Mhm.
Because your lordship knows that till 2016, the Surface Act doesn't allow any of the financial institution to allow anyone to give facilities under hire purchase or leasehold rights. These provisions were not there till 2016. By way of amending this provision, this was inserted that yes, financial institution can help it by two particular provisions. One is the hire purchase and one is leasehold right can be given. Then this property becomes secured. Then this become a secured creditor. I'll show this statute, man, how it can be secured. And my one limb of argument will be on the Transfer of Property Act, Section 73 of the Transfer of Property Act.
So you are claiming that you are a secured creditor.
Yes, that's what I will want to show you.
So,
But I like to, that's why I said your lordship will please note down the leasehold, the lease that was entered, specifically they said the land will remain with us. Title of the land will remain with the ATCA. Now two situation arrives. Now if the title of the land remain with the ATSL, then how I can be secured? Because the money has been poured in and this becomes a public money. Ultimately public money. Now, my lord, the facts of the case which runs into it that we have given, he invested money with the for the garden, this leasehold, and he was running the garden. But what has happened that he could not pay the PF dues, which is due to the employees. So ultimately, the PF has issued a notice to him that these are the PF dues. You please clear it, otherwise we'll take the garden. Ultimately, the PFDs could not be paid, and they decided that this would be paid. This we have to auction this garden. So once they issued a notice for auction, we came to this High Court in first round of litigation, but the auction failed. There was some interim order which was passed by this court, but by the time the first auction failed, then they decided to again re-auction again this particular garden. This time when the auction was made, we moved this honorable court, but there was some protection which they can go ahead, but this money will be deposited in the account of the Provident Fund Department. This was the order that was passed. Some protection was given. In the meantime, they put on auction, it was sold. And this particular two gardens was sold at the point of 8.78 crores total. 8 points, both the gardens were sold 8.78 crores. Both the gardens.
total.
Total of both these gardens. 8.78 crores. Hey, the figures, sir. See the figures. 8.78 crores.
So in the auction, it came 8.7, 8.78 crores for the two gardens.
42 gardens.
Mm.
Now,
That
My
money,
lord-
that money is lying with the
now,
Provident
now,
Fund.
yes. Now the PF dues,
Mm.
which they claim
What
was
is the amount?
2.2 crores.
2.2 crores.
2.2 crores.
Yes.
Now what, if you minus 8.78 crores from 2.2 crores, it is come to 6.6 crores,
Mm.
which is lying with them. Now, the matter again was listed before this court, and the court said, no, we will not keep this interim order, we'll vacate this interim order subject to final outcome of the writ petition. So now the money is lying with them.
Hmm.
That 6.6 crores, but by that time one application was filed by the ATCL. They said that whatever the money is with them, the bonus which belongs to the employees, that has to be paid. Even that was a loss running garden, 20% was paid as a bonus. I could very well understood the period which the garden was leased out in 2023, maybe you have a right. You have a right, ATCL a right. But the second time when they came up before this court and they said that no, the bonus has to be paid. I don't understand how the bonus could be paid when the period, the auction was already done and it was, and the entire liability shifts to the new owner as it is basis. So whatever maybe the amount also was disbursed. Now
That bonus has been paid.
bonus has been paid
For which year?
for 2 years.
For 2 years.
Yes, 23, 24, 24, 25. 23, 24, 24, 25. And the Bodhi garden was sold in the year 2024.
That's, these gardens were sold to whom now?
To one Dinesh, he sold to Sri Shyam Tea Company,
Okay.
to one Sri Shyam Tea Company.
So, their party here.
They are not
They're
required.
not-
Not a part.
But as far as this thing is concerned, that bonus,
They once, my lord, I'll tell you, lordship. they
no, the
approached this-
bonus for 2024-25.
That also has been paid.
So
They-
I mean, then that party will be aggrieved by that.
No, what has happened, they.
How
filed-
can they pay it like when this is owned by them?
No, but the money which has been is from the total which was lying with the PF. From there, the particular amount is in this. They came up before this court. Second time they came up with an application. First, they said the bonus because already that will be subject to final outcome of the writ petition. So the money was lying with the PF. Now PF authorities has to be paid. They want that this money should be paid out of the pocket from the PF amount which was lying with them. So they filed an application before this court. We made an objection. We said, number one, how could you have paid 20% of the bonus where you cannot do it because it's a loss running garden?
So that has been decided by ATCL.
Yes. Now, my lord, when we argued the matter, that was in full swing, the application which they have filed. Now, the court also has questioned a lot of things to them. Ultimately decided to withdraw. Either the court said we have to decide on merit, that whether number one, that whether you put 20% of the bonus, how can you do it in a loss running garden? Maximum 8.33 as per the provision of the act, you are entitled. Number 2 point is 24-25. How can you get it because already the garden has been sold? You cannot claim. Now, thereafter, the court said, okay, we have to decide on the merit of the case. But subsequently, they decided to withdraw that application. Ultimately, that application was withdrawn. And we have been told that from the fund of the PF, that has been paid. From the sale proceeds. So that is the position of the case, man. Now we have approached this honorable court. These are the factual part of the case. I'll show the lease also, lease entered between the leaseholder and the lessee, the ATCL, and how they are protected, the ATCL, that I have to show it. And whether the question which have to be decided is whether they are entitled, we are entitled to get back that amount which is lying with them. Number two, that whether by we have a leasehold right, without those, the land which is not been mortgaged, whether we are entitled, being a public money, to refund this amount. Number three, all this money, term loan is already lying with the ATCA. Whether they can enjoy the fruits for that 30 years, which is only after 1 year it failed.
The term loan has been paid to the leaseholder,
To
right?
the- No, to the ATCL.
ATCL,
Because
why,
that-
why
No,
ATCL?
ATCL, ultimately, the leasehold premium, my lord.
Huh.
Leasehold premium. As per the RFP, this will directly for 30 years, it will go to the ATCL. I'll show it, leasehold rights. Leasehold rights for a
Okay,
period
the,
of
mo-
30 years.
the loan has been taken
There-
from you,
Because
that
ultimately.
has been used for premium,
Yes.
not
lease-
for, no, not for the upgradation of the garden.
Upgradation of 4 crores has been paid. Upgradation.
That is, that is, I mean, cash credit facility you have.
Cash
given.
credit, 4 crores.
There is cash credit,
Cash
that,
credit facility.
4 crores is the limit, right?
Limit.
Upper limit,
That's limit, yes.
upper limit.
Upper limit has been decided.
Upper
And that
limit.
will go to the leasehold premium to the ATCL, which they have not denied. It is lying with
So
them.
2.4 crores you have paid for the premium.
Premium.
Okay.
4 crores of running of this garden, because the garden was not in a good condition, good
Mm.
shape. So the garden has to
Mm.
run. So
Mm.
how it can run?
Mm.
So they said you have to approach the financial institution. That's the fact, they are not denying it. Now, whether the question to be determined by this court is whether number
Now
one.
ATCL has already auctioned it.
No, yes, by way of RFP.
I
it
mean,
has been
not by ATCL,
Yes.
but.
They participated.
Mm.
They, my lord, the money, the term loan also, which is period of 30 years, is lying with them. Is lying with them. So whether we are entitled being a public money, and whether by virtue of this statute, whether we have got all right over that particular property, maybe it is not by way of mortgaging this land, whether through leasehold right, whether we have got a right or not. This is the point to be decided by this court. This is an important point. I have tried to check certain judgment of the Supreme Court. This type of judgments I have, subject to what my learned friend says, that whether any judgment has been laid down by Supreme Court on this count. I have researched, my learned friend research, we could not find out any judgment to this effect. Because these, what I found under the statute 2016, these two provisions were not there. Hire purchase, leasehold right. Otherwise, your lordship knows that the business will come to a standstill. There will be no development. That's why by virtue of this, Parliament decided to amend it. And they try to insert these two on a hire purchase or leasehold right. You can approach it. Otherwise, my lord, there will be no development in it. Why the bank, any financial institution will mortgage, will give financial help to any of the party? They will not. If one is secured by these two provisions, two particular components, hire purchase, leasehold right, then you can do. So this is the area where I have not found, my lord. Let us be honest. I will again go through it, whether any judgment I could not find it. Any judgment.
Correct.
Now there I
So
have
basically,
been told,
basically your
I-
case, basically
I have
your
been told,
case.
I have been told there was a debate, parliamentary debate on the issue.
Hmm.
I think Arun Jaitley. When the honorable late minister Arun Jaitley, I think we have got that. We have got that. Parliamentary debate was also there.
Hmm.
But it didn't, because ultimately Arun Jaitley also.
So basically, it's a case of like giving a loan,
Yes.
to somebody, and somebody has actually utilized the hypothetically, the government land has been taken and he built up a structure there.
Yes.
Now you don't have any security. You have only given given that property, not that loan amount. But you don't have any security as
True.
such. But now you are saying that by leasehold rights, because that money has been given and the premium has been paid to the ATCL.
Well, I'll
So
tell
you have some right, secure right.
Yes, secured. Right. Now, one thing I have to tell you, Lordship, that whenever this type of financial help is given to any of the party, the normally duty of the bank is to keep secured.
Hmm.
Now, maybe the bank may say that you have to give some mortgage, some collateral security you have to give. Now, if that collateral security is given, suppose the not in that, some other area of that equivalent to this particular amount, maybe 2 crores, 3 crores, that it is secured. Now, if it is secured, then maybe, my lord, there is certain other forum where you have to approach. Let us say, because we have to point out before the court, there are certain other forums. You go to DRT. DRT, there are provision where you can definitely go ahead, file a way attachment of that. Attachment. So these are one aspect of the matter where these secured creditors are minor. They are backed up by a statute where you can approach before one forum. This is another one forum. But here we came by filing a writ petition. Being a public money, where this money has been, it is lying with you, that entire 2.4 crores, which is the 80 also margin money, let us say 2.4 crores, with the term loan for a period of 30 years is lying with them. Whether that is enter, because these are public money, whether this can be refunded back to us.
Correct.
So these are the issues where Lordship has to look into it. I'll just give one list of dates
Yes.
to your Lordship. I thought that let me put the facts.
Yes, yes, yes.
List of days you have to give it. I'll provide you my unprinted list of facts. Like to go to the list of dates, my lord?
Yes, yes.
Please see first 6/1/2023, my lord. The letter of intent issued by ATCL, whatever I narrated the facts, my lord.
Yes, yes,
It
yes.
is all there. The 1 or 2 dates, possession notice, when is a fresh sale notice, these are all been. Yeah, so other side could be.
One 1874 was filed by you
Yes,
earlier occasion,
correct.
but auction failed.
Yes,
Then you came back again.
yes.
So there are two gardens, one is Dipling and one is Rosabari.
Correct.
So both have been given to this party,
Yes. Both.
Sri Shyamti Company.
No, it's given to one Dinesh. Shyam is sold to some, right?
Shyamti.
Yes. Sorry, my lord, it given, the successful bidder is Shyam Tea Company, Shyam Tea Company.
So leaseholder was there, this Dinesh
Yes,
Kushwaha. Then it
He
was,
could not run the garden.
so the auction was done,
Auction was
auction
done.
it has gone to this Shyamti.
Yes, correct.
Shyamti. Now only thing is that like, your money is there.
They'll be like
Six
this,
crores are there, 6 crores amount has been recovered from the
Whether-
auction.
whether we have got the right to.
Whether you have the right to
Right
claim
to
there.
recover it from PF authority which is lying with them. And
But
whether
PF
we-
authority, they have already deducted their amount.
Yeah, they have deducted. They have no due.
You are only a custodian.
Yes.
Yes.
Hmm?
Yes, there was
Hmm.
an order passed
Hmm.
on 4/4/2024,
Hmm.
where their bank claim is against the balance amount, the amount of PF that was due,
Hmm.
that we have priority of charge over.
You got it, you got
We
it.
got it.
Hmm.
Now the balance amount is lying.
Hmm.
So as per the court directions, whatever the court tells, then we'll pay accordingly.
Hmm.
That's how.
So it is with you, so whatever the court decides, and you can do it.
See, or either we should Punjab. That will. as
So
per-
the contesting party is them.
Yeah.
So you don't have much role to play,
Their role
As
is
of-
very limited.
very limited.
Their
con-
role- their
contesting
role is
party
to-
that is it.
Their role is to listen to us, and if something wrong factual part, they will definitely, that's why I'm saying, I'm telling them, please correct me whether factually because these figures are very important.
Hmm. Correct.
One correction,
Obliged.
small correction, your lordship will please do it.
Hmm.
This garden, one of the garden,
Hmm.
Rajabari,
Hmm.
was sold to Surya Setia.
So
which
somebody
is-
else that.
Yes, there are
So two gardens, one was to
Sorry,
Shanti, another one is
One
somebody
is-
else.
One is Vishnupuria Tea Industry.
Ah,
The Vishnupuria Tea Industry. We'll give a correct list of dates, my lord.
okay, that's a good problem.
Updated list of dates.
Yes, now
Now
let us
please
go to the merit.
Let's the merit of the case. Please look into first RFP.
RFP at page.
RFP at page 33.
The first, let us go to the, I mean, that lease deed is there.
That's why I'm saying RFP. Please first see the RFP.
Okay.
That is certain clauses are important.
Mhm.
RFP
Page 33.
33. Please mark certain clause your lordship can note down.
Mm.
Page 40, page 42. Well, I'm extremely sorry.
Hmm?
My lord, one thing I have to say before everything. I'm thankful for a learned friend. Please look the order of 4/3/2025.
4-3?
2025. 4/3/2020. I did not notice also. We don't notice. Now I am just noticing it.
Yes.
4/3/2020, please see.
Mm-hmm.
4/3.
4-3-2025, right?
Yes, yes.
Mm.
Lordship got the order?
Yes.
Yes.
So respondent number 7.
Your lordship was, it was a council appearing
Mm.
for the council industry and commerce department. 4/3/2025.
Oh.
I didn't notice.
And
No,
I directly,
didn't go to others.
I directly went to the
So I
bottom
thought
part.
my learned friend, they were
Yes,
looking
yes,
into
yes,
and
yes.
fine.
Mm.
I think.
No, I was little bit recollecting, but
I didn't recollect also.
I
because
was
we
little
go
bit,
through
I was
the-
thinking maybe, but
I-
it was not heard at that point of time. Only notice was issued, so
But even
so it
then,
went off my mind.
if this will, I would have started with this first.
No,
I would
that's
have
fine. I mean,
trouble-
like, I
would have
also.
not troubled this
I also-
foot also.
Okay,
But
then.
I thought that this was a case where law can be laid down. I didn't find any judgment also because subject to what they have, whether they have gone through it. I think that's a very interesting subject. I
Yes,
tried
yes.
to research.
That's why I was keen to hear about hear this matter.
How this being a public money, leasehold right, whether what is our right. I try to draw the analogy from Transfer of Property Act 73. Interest, what the interest was for? Any interest thereon. Any interest thereon on Transfer of Property Act.
Yes,
Suppose-
I mean,
What is the right? Suppose the mortgage, suppose there is a land acquisition proceeding which takes over, tenant is there, then what happens? What right over tenant gets it? Whether he will get some right to any interest thereon. So this is, we tried. I thought that I'll just try.
yes. I
My
was
learned friend was helping me. But anyhow, your lordship.
Anyhow, can't be helped. I mean,
Yes.
can't be helped. Let this matter be listed before before an appropriate bench without.
Sorry for.
No, nothing. No, we are, this court has also got familiar with certain things which, it's always, I mean, it's always a learning process, always a learning process. Whatever you heard, right?
And I am
Whatever you
thankful
hear.
to my learned friend that they have shown others I would have proceeded. And only after 2 hours. that
Yes,
we
it
get-
would have been difficult. Good.
I'm deeply obliged. Obliged.
Yes.
Item 6.
Mr. Datta, what is happening?
My lord, affidavit not filed, but I've received some instruction. But affidavit not filed, my lord.
Why?
My colleague
You
was
have taken so
appearing
much
this
of
matter.
time. Who is SB Chaudhary?
He was there, my lord. But
What was the case all about?
settlement, my lord, the private respondent was settled, my lord, and petitioner was initially, as per petitioner, my lord,
Hmm.
says that he has filed RTI, but document not given to him, my lord. But my record says, my lord, he has already received the RTI document, my lord. And as per my instruction, my lord, the petitioner's bid was defective because above 10%, my lord. There is a rule, my lord.
It's for this, I mean, this ghat,
Yes.
operating the
Yes,
ghats, right?
yes, my lord. And petitioner's bid himself bid was defective, my lord, because that was above 10%, which is mandate of the law, my lord, after the amendment of the financial rules, my lord. And some gray area is also there for the private respondent, my lord. But before that, my lord, whether the petitioner has the locus to challenge, my lord, because he himself is a defaulter, the defective bid, my lord.
If he's not there, did he file an affidavit?
My lord, my lord.
We'll post it after some, because he's not there.
My lord, my lord.
None appears for the petitioner when the matter was called for. None appeared for the petitioner when the matter was called for. However, Mr. S. Datta, the learned standing counsel for PNRD department from Assam is present. Anybody else is appearing?
I'm appearing for respondent number 7.
Mr.
G. Bukulia.
G. Bokulia, for respondent number 7. Mr. Datta submits that he has received the instructions in the matter and prays for 2 weeks' time to file an affidavit in the instant case. Prayer is allowed. Let the matter be listed after 3 weeks.
Fine.
You file an affidavit?
I'll file immediately. Hello.
Thank you, Lordship. I am for item number 8, Lordship. In this case, Lordship, affidavit has been filed, Lordship. I may be allowed some time, Lordship, for reply, Lordship, for filing reply. Who is time?
Item
A
7.
reply has been filed.
For item number 7, they have filed, Lordship, but I am for
Item number 7 you have filed.
I am for item number 8, Lordship.
I mean, matters are different or what?
No, same issue, Lordship, but the factual aspect is something different, Lordship. 2 weeks, Lordship.
Lordship,
So this
item
item number, yes.
Item number 7, we have filed our affidavit, Lordship, but there is an inadvertent mistake, Lordship.
Then
Then I pray for correction, Lordship.
correction cannot be done like that.
I will file amendment petition, amendment, Lordship. I will be filed, Lordship. For
But
only
what
one,
was the
Lordship, we
mistake?
come to the page number 67, Lordship.
Yes.
Lordship, there is inadvertently written as 19(1)(z). It should be Article 15, Lordship. 19(1)(z) is not come
Okay,
here.
19(1)(g).
Yes, Lordship. Maybe for oversight, Lordship.
Only that much.
Yes, Lordship, only that much. And item number 8, we have received instruction and we want to file our affidavit on behalf of respondent number 1 and 2, Lordship.
This 19(1)(g) will not materially affect anything. It can be like this also. Right? This is not going to affect anything.
Lordship.
My lord, with regard to the item number 8, we have filed our affidavit already, my lord.
Page 64 clearly says, my lord, up-to-date revenue receipt not found. Photograph of buyer and seller with alia staff not found, hence not recommended.
So that's what he wants to reply to.
Yes, sir.
That's what he wants to reply to.
And Lordship may permit us to file an affidavit on behalf of respondent number 1 and 2 in item number 8, Lordship.
Item number 7 pleadings are
We have
complete, right?
already filed. And
7 pleadings are complete. 7 pleadings are complete. So you write, MS, your name? So and so so and so the learned counsel for the petitioner in WPC number 5896. Service is complete in this matter. No, service nahi, that pleadings are complete in this matter. Then you write in WPC number 6385, the learned counsel Mr. So and so
AMS, my lord.
appearing for the petitioner submits that he has received the affidavit in the instant case and would like to file an affidavit in reply in within a short time. So he prays for 2 weeks' time. let both the matters be listed after 3 weeks.
Breaks, madam.
3 weeks.
Well, the matter relates to dissolution of board of directors, my lord, of a cooperative society.
Yes.
The impugned orders are
The cooperative
That-
societies,
Annexure 5 and Annexure 7.
cooperative societies. Annexa?
5 and Annexure 5 is at page 50 of the petition.
Yes.
The first order dated 4th of November 2025 reads,
Yes.
my lord,
Hmm.
with reference to the subject cited above, it is hereby informed that in violation of section 34, section 41, and section 26(3) of the Assam Cooperative Societies Act 2007, amended from time to time, the formation of BOD, that is Board of Directors, on 19/9/25 and 26/9. These 2 dates, sir, my lord, the first meeting was actually, my lord, scheduled on 19/9, my lord,
Hmm.
after notice.
Hmm.
But due to lack of quorum, my lord, it was adjourned
Hmm.
till 26/9, my lord,
Hmm.
25. And so on 19/9/25 and 26/9/25 is resolved immediately, and one-man management committee will take over as per section 41, section 6 of the Assam Cooperative Societies Act 2000. This is for information, madam. It was issued by the Deputy Registrar of Cooperative Societies, Yohagar. Your lordship will, for the time being, see that there is no reason assigned except the violation of the sections, not non-speaking. Then, my lord, there was a representation from our side.
You are who? Who are you?
My lord, I am the society, my lord.
You are a society.
I am the society.
And in that election in your society,
Yes, my lord.
hmm,
AGM, my lord.
Huh.
At AGM, that election, my lord.
that has been dissolved.
That has been dissolved, my lord. Just after, my lord, we submitted the proceedings.
Hmm.
We are required to submit the proceedings after
Correct.
the
Hmm.
AGM is over.
Hmm.
That we did.
Hmm.
And, my lord, instead of, my lord, passing any order, they
They have dissolved. AGM was there, then it was, I mean, then they said that there was some violation in the thing.
Yes, my lord.
And as per this, this order was
not
passed.
granted.
And how you are agree with this?
We are agreed.
You are the society, right?
We are for the society, my lord. And, my lord, they had to pass order if at all, my lord, anything, my lord.
Hmm.
I'm not saying I'm denying, my lord. I'll come to that later, my lord.
Hmm.
If at all they had to pass that order within a period of 2 weeks of submission of the receipt of the proceedings,
Hmm.
which they didn't do.
Hmm.
And by that, my lord, by provisions of law, it becomes deemed approval.
Hmm.
These orders came after that period, my lord, which is given to them as per section 45 of the Act.
Hmm.
But I'll show.
No, I could not understand how you are aggrieved by this.
Yes, my lord.
You are a society, correct?
I am the society, my lord.
Hmm.
I held it, my lord. This society
No,
is
there is, see, this is your society,
exactly, my
and
lord.
in your society, there was an AGM. Board of directors, I mean, were selected or nominated, whatever. Then after then there was a submission of report.
My
Report has gone.
proceeding.
Proceedings report has gone to the registrar. Then the registrar found some illegalities there. He found that there is some non-compliance, some certain.
That's what
Correct. Then he dissolved it, and he said that like till the time, I mean, that new
A
body,
one-man committee?
new body comes.
Huh.
This is, I mean, it will be run by one-man committee.
One-man committee?
Now, you being a society itself,
Yes, my lord.
how you are aggrieved?
My lord, I am aggrieved because, my lord, there is no governing body, my lord. I cannot take forward the things of the society, my lord. We are a cooperative society, my lord. We run a thrift society. It's actually a thrift society under the law, my lord, which is provided for. And, my lord, this is the first instance after years, my lord. This is a very old society, and the thrift society is very well known, my lord. In the recent times, my lord, we changed our name as per their requirement because banking license was not there. And these are the facts, my lord. And now, my lord, all of a
I
sudden.
mean, I see, like, you'll have to first tell me how you are aggrieved. So, see, if any of the board of directors would have approached that he is aggrieved because he was duly selected or duly nominated, but that has been wrongly done, that he is a person aggrieved.
My lord,
Now,
here.
now the society has been, a one man committee has been already appointed. He's taking care of it. Now, obviously, like this one man committee will not go forever for
I
eternity.
am the chief executive officer, my lord.
Hmm.
Everything is done under me. Proceeding is sent, my lord, in my signature, man.
You are the chief executive
Yes,
officer.
man. I represent the society in that manner, man.
You are not saying that you are chief executive officer.
My lord,
You are not
managing
saying.
director, my lord.
Hmm?
Managing director.
Gunin Dhingia.
Yes, my lord.
Gunin Dhingia, you are saying in a statement that, okay. Chief executive officer of the society.
Yes, my lord.
Okay. Okay, let's proceed. Let's
Yes,
see.
my lord. Your lordship will first come, my lord, to Annexure 1, my lord.
Yes, Annexure 1.
Annexure 1, page 22, my lord. How this process is taken forward, my lord. Your lordship will, my lord, lordship is aware, my lord, the term of the society is for, my lord, the board, my lord, rather, 5 years, my lord.
5 years, yes.
5 years.
So this is a notice for
Notice for
okay.
the AGM, my lord.
AGM,
And
yes.
yes, my lord. This is dated 19/8, my lord. The date may kindly be recorded, 19/8/2025.
Yes.
I have given the vernacular also, my lord.
Yes. So this is a notice for
My lord,
19/8/2025.
before that, my lord, we are required to publish that electoral roll, my lord.
That has been done.
That has been done. This is to seek objections. If anyone, my lord, has, someone wants to,
Correct.
my lord, bring
Got
in
it.
some names
Yes.
and all that.
Yes.
So the process of upgradation of voters list as per section 2060 of the Assam Cooperative Societies Act has been completed for the purpose of AGM for the year 25-26 to be held and for election of directors. Therefore, the shareholders having voting rights are requested to ensure the inclusion of their names in the said upgraded list. And in the event of any objection from anyone in this regard, to contact the office bearers of the Cooperative Society.
Yes.
The upgraded list is hung alongside this notice for inspection.
Yes.
Your lordship will kindly, I have got photographs also with me. Then the vernacular one, my lord.
Yes.
Then, my lord, 38/2025, my lord. The next letter is, this has kindly referred to the subject mentioned. I have the understanding to hereby inform that the forthcoming annual general meeting AGM of the aforementioned society proposed to be arranged on 19/9/25 is to dispose of agendas as per notice issued to its shareholder, member copy of which is enclosed for your reference, which may please find. Therefore, your further action is so and so. This is the intimation to the
Deputy Registrar.
my lord. Yes.
The agenda has been given.
Agenda is given, my lord. Your lordship will find. At 8, my lord. Completion of process of selection, election of new members of board of directors. Has your lordship got it?
Page.
Page
25.
25. 8.
Hmm?
Agenda number 8.
8, yes. Serial number 8.
Yes, ma'am. Serial number, selection, election of new members.
Board of Directors.
Directors to start functioning from the financial year so to the financial year 29/30 as per the Assam Cooperative Societies Act. And my lord, other agendas. And the notice, my lord, it is written, the honorable shareholders of Development Thrift and Credit Cooperative Society Limited, erstwhile Urban Development Bank Limited, hospital road so and so, to carry out the fixed agenda is scheduled on Friday, 19/9/25 at the time and place mentioned below.
So it will be held on 26.
19/9, and thereafter, my lord, if for any reason, my lord, it cannot be held for lack of quorum. The next paragraph, my lord.
Then 26/9.
And then 26/9. Exactly, that is what had happened, my lord. So 19/9.
First time it could not happen.
Yes.
So 20th you have intimated.
26/9 is the meeting.
No, annexer 3.
Yes, ma'am.
The 29, you have intimated that.
Yes, ma'am.
That due to
No,
lack
The
of
adjourn
forum.
notice of adjourn meeting.
So lack of forum, so it has to be adjourned and it will be held on 26/9.
Yes, ma'am.
So that you have written to deputy registrar.
Yes, my lord.
Yes, then what? This is the accept,
Yes, ma'am.
accept of this,
Except of the
that is a
proceedings
translated
of that
copy
day,
of the
proceedings of that day.
due to lack of forum, yes.
Then the.
So what is the forum actually?
My lord,
Forum, what is the forum?
quorum is given.
Ah, no, quorum, sorry. Quorum.
Yes, ma'am, quorum to. Ma'am. I'll place it, provision, ma'am. Then thereafter, my lord, so it was held on 26/9 accordingly, my lord, as was notified earlier. And there-
26/9.
26/9, my lord.
It was held, then you reported on 10/10.
On 10/10/25, my lord,
Hmm.
is the date on which we submitted the proceedings, my lord. And your lordship, kindly see at the bottom, my lord, received. Sign was, seal is there, 10/10/25.
So you are basically, you'll be hopping on this date also, 10/10.
Definitely, because that deemed approval is there.
Deem confirm.
Deemed approval is there.
Hmm.
But if this is 10th, my lord, they had to pass that order within 25/5, 25/10, my lord. 15 days, they didn't do it, they passed the order on 4/11. So that order in any case, my lord, cannot stand the scrutiny of law.
Okay.
Now, my lord, your lord, just one thing, my lord. Kindly come to page 31 once. But these proceedings were, amongst others, were
31.
page 31, man. That pre-page, man.
31 is an SMS.
Page 30, vernacular, man.
Yes.
At the bottom, your lordship will kindly see. Pratyo Khunwal, Hisab Porikok, Homobai Committee Homo. So he was the appointed observer. I've shown this because, my lord, all these proceedings were done, my lord.
Before authorized observer.
Yes, authorized officer, under the superintendence of the authorized officer. Then, my lord, the proceedings were submitted. My lord, one thing, my lord, in the proceedings at page 36, your lordship will kindly come.
36.
Yes, ma'am. At the bottom. As per item number 8, has your lordship got it?
Yes.
The chairperson put up, this is translated, my lord, the vernacular is there.
As per agenda item number 8.
8, my lord. The chairperson put up serious subject of completion of election process of director member for the period of cooperative year so and so. He also informed the House that one of the members, after receiving nomination as per the notice published for election of director members in the meeting, did not submit the same in time, for which a solution for such time was required to be necessary as per the chairperson. Taking into account of the said issue, the shareholder member Srijut so and so stated that since some members did not submit the nomination paper collected by him to compensate the same, the members present in the meeting might select a competent member with the consent of all to constitute the board of directors. At that, the chairperson, having asked for opinion from the appearing members who agreed that the board of directors functioning presently declared their resignation through the chairperson. So the earlier body declared their resignation through the chairperson Srijut Niren Chandra Bhattakur Ole, and the house dissolved the board.
No, what has happened exactly? I mean, in this.
So this is the constitution of the new board, my lord. So
They said that some people did not file nomination paper in spite of taking the nomination papers.
Yeah, they didn't file, my lord. And so therefore.
So they decided.
This is a selection, my lord. Actually, this is a selection. So there was no election, apparently, from the proceedings it is seen.
So whether selection can be done?
Yes, madam. It is done. Functioning president.
Selection, who will do the selection?
In view of the, under that, their officer observer is there.
The observer is there, but
Yes.
who is the authorized person to do selection if it is selection?
My lord, it is by the, through your lordship will kindly note, Srijut Niren Chandra Bhattakur Ole, If I may read out the rest of the proceedings, madam.
Yes, yes, yes.
In view of the dissolution of the earlier board of directors to conduct the present meeting, the below named members proposed and seconded the name of Miren Chandra Bhattakur as president and the group of directors under his leadership to conduct the affairs temporarily till the new executive committee assume the charge of affairs. Proposer Sijun Manoj Ghosh, supporters.
So Dhiren Chandra Bhattakur is the one-man person who has been
Yes,
appointed.
Yes, madam. In view of the said proposal, Niran Chandra Bhattakur again took the chair and requested to begin the process for selection stroke election of members of the board of directors. As per decision of the shareholders, the following members have been elected to the board of directors, and the names are given, my lord. I have given the excerpt, and the actuals are here. In the vernacular, কাৰ্য বিৱৰণী, it is there. অংশীদাৰসকলৰ সিদ্ধান্ত ফলস্বৰূপে নিম্ন উল্লেখিত সদস্যসকলক সঞ্চালক মণ্ডলীলৈ বাছনি নিৰ্বাচন কৰা হয়, page 46. Page 46. Has your lordship got it?
Yes.
So this is the new body. They said উক্ত অংশীদাৰ বৃন্দ সঞ্চালক মণ্ডলীলৈ নিৰ্বাচিত হোৱাৰ অন্তত আজি সভাই তলৰ প্ৰস্তাৱটো গৃহীত কৰে। ডেভেলপমেন্ট থ্ৰিফ্ট এণ্ড ক্ৰেডিট কোম্পানী কোঅপাৰেটিভ ছ'চাইটি লিমিটেডৰ যোৱা 26/9/2025 তাৰিখে অনুষ্ঠিত হোৱা বছৰেকীয়া সাধাৰণ সভা এই কাৰ্যসূচী অৰ্থাৎ অষ্টম সূচীত প্ৰস্তাৱক আৰু সমৰ্থকৰ জৰিয়তে যিসকল অংশীদাৰ ব্যক্তি বিশেষক সঞ্চালক সদস্য হিচাপে বাছনি অথবা নিৰ্বাচিত কৰা হ'ল, তেখেতসকলৰ সমন্বিতে 2025-26 পৰা 29-30 সমবায় বৰ্ষলৈকে কাৰ্যনিৰ্বাহ কৰিব পৰাকে সঞ্চালক মণ্ডলী গঠন কৰি সৰ্বসন্মতিক্ৰমে প্ৰস্তাৱ গ্ৰহণ কৰা হওক। লগতে নতুন সঞ্চালক মণ্ডলী অন্তৰ্ভুক্ত লাভ কৰা অথবা সঞ্চালক মণ্ডলীক পূৰ্ণাংগতা প্ৰদান কৰা সদস্যসকলৰ নাম তলত পুনৰ লিপিবদ্ধ কৰা হওক। The new body, the names are again noted down. Then নৱম কাৰ্যসূচীৰ অধীনত অসম সমবায় আইনৰ 30 ধাৰা অনুসৰি অন্যান্য সুকীয়া বিষয়ৰ ওপৰত আলোচনা not necessary, so the new body is constituted. Then, my lord, other issues, my lord, profit and loss, balance sheet, all these things. The
Okay,
normal
so
transactions.
new body was formed. So
Yes.
till this time, there is no dispute.
No dispute, man. Now this proceedings has gone to them. On 10/10 they received it.
Yes,
As I have already shown, my lord.
correct. Now,
Yes. Then thereafter, my lord,
on 4th November, they've come up with
they 4th November.
what-
By that time, my lord, I was already, my lord, the proceedings were already
over.
deemed to have been approved.
Okay.
As per 45.
Now, with reference to the subject law, it is hereby in violation of section 34, 41 and 26(3). What are
Yes.
those?
Yes, man, let us go to all those things, man. First 26(3), man. 26(3). 26(3).
(26)(3).
Yes, man. Chief executive of every cooperative society within 20 days of closure of the previous cooperative year shall prepare a list of members with right of vote and a list of members without the right of vote. Valid for the current financial year, list shall be affixed on the notice board. My lord, I have a photograph of. This is the photo. Well, perhaps it's time for lordship to.
So I'll just
Yeah,
come
ma'am.
back in 5 minutes.
So, my lord, we are on the sections, my lord.
Yes. Section
Which
26,
the earliest-
26.
26, my lord, if I may read.
26(3).
Read.
Yes.
Prepare a list of members with the right of vote and a list of members without the right of
No,
vote.
Let us read the whole thing.
My
The
lord.
chief executive of every.
Of every cooperative society.
Hmm.
Within 20 days of closure of the previous cooperative year shall prepare a list of members with the right of vote and a list of members without the right of vote valid for the current financial year. The list shall be affixed on the notice board of the head office of the cooperative society for information of all members, and any member not satisfied with specific instances of inclusion or non-inclusion of members in the list may appeal to the board within 10 days from the date of the affixing the list on the notice board for re-examination of the records, and the board shall within 40 days of closure of the previous cooperative year review the list, finalize it, and have it affixed on the notice board of the head office of the cooperative society, provided that a member, so-and-so or member of society shall not be under, my lord, this is not applicable to office. In case of equality of vote, the chairperson shall have a casting vote. So this is 26(3), my lord.
So you are saying that that has been done?
Yes, my lord, I have raised the records.
That notice has been pasted
Yes,
there
my
in
lord.
your
Yes,
head
my lord.
office?
Even photographs are also here of that.
And
affixation.
there was no complaint?
No complaint, no, man. And they had full, my lord, right of entry to the office, my head office, my lord, anytime, my lord. They never came, my lord. They never inspected. Only they deputed that observer, my lord, for the purpose of annual general meeting.
So no complaints from any quarters?
No, no. Not at all.
Okay, so you are, as per you, 26 is complied with?
Right.
Okay, then
Then, my lord, next one is 34 Avenue.
34 years.
34 my lord, relates to quorum of meetings of General Assembly, my lord. The quorum for a meeting for the General Assembly shall be specified in the bylaw, but shall not be less than 10% of the members eligible to
Total members?
vote. Yes, my lord. Total members we have stated in my at paragraph 6, my lord. Paragraph 6. I'm sorry, my lord. Para 3. Paragraph 3, my lord. Total number is mentioned, my lord. So therefore, only first day on 19th of 19, my lord.
19 it was not there.
No, it was not there. So
Quorum
it
was not
adjourned.
there.
And it was held on 26th as notified. And your lordship will kindly see in section 34(3), my lord. It provides for that adjourned meeting, my lord. 34(3). Has your lordship noted?
Yes.
If at any time in a meeting there is no quorum, the presiding authority shall adjourn it to such time or date as it thinks fit, and announce the same at once, and the business set down for the meeting shall be brought forward at a subsequent meeting with whether at such meeting there is a quorum or not. So in the adjourned meeting, quorum, my lord, issue will not come. That is a ground taken by my friend, my lord, in his affidavit. So but that will be redundant, my lord, for the purpose of adjourned meeting. Then, my lord, there is another section. In this. 41, my lord. Section 41.
Yes.
41, my lord,
Yes.
relating to elections. 41(1) says the superintendent direction and control of preparation of electoral rolls for and the conduct of all election to a cooperative society shall vest in the register. It shall be the duty of the register to prepare the voters list with eligible members to arrange for holding elections of directors, delegates, and or representatives to the delegate, general body, and representative of the society if fallen vacant. The election of directors to a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board member. So they should suggest that, my lord, this was done timely, my lord, and with notice to all members, and under the supervision of the observer appointed by the RCS.
Where is that?
My lord?
Your observer?
Observer. Observer, my lord, in the proceedings, my lord, signature.
No, I mean in 41, where does it say?
41. এখন নতুনটো নাই yes ma'am. 6, my lord, 41-6, where a board fails to arrange, it is failing to arrange holding election for the, before the expiry, this will not come. But here they have mentioned, the registrar shall convene a general meeting by appointing an officer of the.
Mr. Bora, where is the section?
Appointment of observer. Yeah, appointment.
Talukdar.
My lord.
Where is that section where an official observer has to be there and what will be the role of his, what will be his duties during the elections? Is there any section on this?
In fact, if your lordship goes through the act, my lord, under the.
See,
act-
there is a purpose of giving, putting the observer,
Yes,
right?
my lord, correct.
So observer has to, if there is any infirmities,
Yes.
then observer, I mean, there is, I think, I mean, I don't know, I mean, that statute will say
Correct.
the duty casted upon this observer to report that there is some infirmities.
Exactly.
Whether that has been done.
Yes.
So that, is there any provision in that line?
In fact, under the act, my lord, there is no such provision, but officially it
Is
done.
there any rule there under this act?
Yes, there is a, my lord, election rules, my lord.
So,
Election will come later.
so otherwise, what will be the role of the observer?
In fact, what is, my lord, what is done?
Then where is this observer thing? But
Yes,
just
correct.
let us understand this. Otherwise, there will be no purpose. Now, if everything has to be done by the, I mean, chief executive officer
Yes.
and his other officers, then there is no point of putting any observer if the observer doesn't have any role to play. If there are some infirmities in holding the election or the selection, whatever, then that has to be reported.
Yes, that report is normally given by the observer, that it is in accordance.
So where
Yes.
is, I mean, is there any a report submitted by the observer?
Yes, on record I have, my lord.
You have,
Yes, yes.
but what is the statute says?
Yes,
What does the
under
statute?
under
say?
the scheme, my lord, there is no reference to any requirement of observer, but this is the practice which is done. Observer is appointed by the registrar, a notification is issued.
Notification is issued by the, that he will be the observer.
Yes, correct, my lord.
That notification is issued.
That is always issued.
That is
my lord.
already there, and the observer was there, that is not disputed. But statute doesn't say about observer.
No,
No,
statute
That's what you're saying?
I have not come.
There is nothing like, I
He is
mean,
the delegate of the RCS, madam.
correct. So, I mean, statute or rule doesn't say anything on this.
Yes, correct.
Rules I have not checked, my lord. My friend is.
Under the rules, my lord, 2019 rules, there is requirement of appointment of returning officer,
Returning officer may be
Yes.
an observer. Where is that?
2019 rules, my lord.
2019 rules.
Yes, election rules, your lordship will find in this book. This book, my lord.
ডাঙৰ কিতাপ খন
Red
আছে ন?
book. ৰঙাখন আছে নে?
This
Yes,
same
yes.
book probably.
Yes, your lordship will find after the statute, my lord, comes to an end, this rule starts, my lord.
107.
107, from 107. Page 111, my lord, rule 4.
No, that book is not there. I mean, they have pasted something here,
Yes,
Well, your
lord-
lordship can.
some notification. আছে নেকি দেখোন? আছে দেখোন তো নাই। আছে? ভালো করে। দেখুন দিন।
Returning officer, my lord, and observer, a little bit different.
Okay, then one returning officer is also one required.
The returning officer normally he
Maybe-
conducts the election
Yes.
and he's, my lord.
The
in
correct,
his-
so returning officers shall be appointed by the election authority.
My lord.
Who is the election authority here?
Election authority is the
Yes.
registrar, my lord.
Register.
Yes.
Yes.
When there is no sufficient staff under the election authority, the election authority shall detail officers from other departments, establishments so and so. The concerned district civil admission shall ensure the returning officers shall be provided 2 copies of the electoral rolls. So was there any returning officer here
My
in
lord,
your case?
That has to be, my lord.
Hmm?
my lord, actually, man, these officers are appointed by the authority.
Correct.
who
So
represented by my friend, man.
yes, so I mean that is a that is a statutory rule. That is a statutory role has to be. I mean role that has to be.
Established. Or by no, unless my lord,
No, that is what the statute says that there has to be one returning officer. So whether returning officer was there or not, that has to be replied by him.
that my lord.
And observer also like you're now
My
both
lord,
of.
yes, the role played by he must have played as a returning officer during the election, man. But this is on them entirely, man. How he was appointed, how.
No, that is on him.
Fine.
But as far as observer, you're saying that observer is a different person.
Observer, normally, my lord, what happens?
He's an independent person.
No, no,
Independent person is
he's an
appointed by the
Correct.
registrar.
Correct, my lord, official from the department.
Department, he-
Normally, the board meetings are there, AGMs are there. My
So
lord,
one
he
observer is there.
oversees, my lord, yes. In each and every board meeting and my lord, general meeting, one observer is appointed by the registrar.
So
Other-
correct, that is
Yes.
what I wanted to see, whether, what is the role of the observer? I mean, whether observer has to mandatorily submit one report or not.
My lord, normally he submits the report because he has to inform or he has to. my lord-
Correct. So I
Yes.
mean, he has been
Intimate, my lord.
deputed, so he has to submit a report.
Yes, yes.
So whether there was any report?
There was a report.
There was a report.
I can place, my lord.
Okay. But both of you are saying that like there is no provision as such. It's
Under the act, my lord, there is, correct, my lord, there is no provision for appointment of observer. At least I don't find, my lord.
Hmm.
Yes. I don't
But
find.
traditionally it is been
Yes,
done.
yes, it is done.
Practice is
It is
there.
a
Practice has been done.
Yes.
But my experience is that observer is always appointed by.
Observer has to be from the department,
from the department.
but there is no, I mean, that statute is.
Here in this case, whether that observer was the returning officer or that my lord.
That they will
That's
say,
clarified.
that they will say,
Yes, ma'am.
correct.
Because the election rules of
So only
2019, my lord.
now thing is that like they say that there are violations of 34,
Yes, my lord.
41
Let
and
them show
26
us
3.
what violation was done, my lord. And these orders are not speaking. And they passed the order at a point of time, much later, my lord, than the 15 days they.
And where is the provision of deem this thing?
Oh, yes, 45. My lord, before that, my lord, there is another order passed,
Which order?
page 53.
What is
Last page of the.
51 is your representation.
53 is, no, my lord, the
51.
51 is my representation, 51 and 52, my lord.
51 is what for what?
This representation is again this order dated 40.
Okay, after this order was passed on 4th
Again, my
November,
lord, then this time, my lord, the other authority, the Zonal Joint Registrar of Cooperative Societies at Jorhat, who passed this order dated 10/11/2025. Page 53, my lord.
the zonal joint registrar.
Yes, my lord. The first order that has been input was passed by the Deputy Registrar of Cooperative Societies, Hyohagar.
See, usually it's a registrar, right? So deputy registrar is delegated.
All
maybe.
day, all day.
It may be delegated.
Delegate,
But
area
wh-
wise, my lord.
But zonal joint registrar, how come zonal joint registrar?
Zonal,
is
my
come-
lord, possibly include some districts, my lord, not only one district. There is a zone, my lord, they have set up.
Okay, what does it say?
Yes, my lord. Let me read. Whereas it is reported by the District Deputy Registrar of Cooperative Societies, Hyohagar, by letter number so and so, dated Jorhat, the 4th November 25, that the Development Thrift and Credit Cooperative Society has failed to hold the annual general meeting election of the society within the stipulated time as per provisions of the Assam Cooperative Societies Act 2000, and the board of directors of the society stands automatically dissolved under section 39. Now here the offending sections are different.
Now they have come with the thing that you have not hold the election within time.
That's what says.
And that's what they say.
That's what they say.
Hmm.
Now, therefore, in exercise of power conferred under section 41(6) of the Assam Cooperative Societies Act 2007 and amended up to date And as per power delegated by government notification number so and so dated so I MH so and so, do hereby appoint Sri Amol Mili, Senior Inspector, Stroke Auditor of the Cooperative Societies, Office of the Assistant Registrar of Cooperative Societies, to perform all functions of the Board of Directors and shall convene annual general meeting, stroke election of the Development Thrift and Credit Cooperative Society Limited to constitute the board within 90 days. This is a fresh process for holding election. Ma'am.
So you have an interim order running here.
Yes, ma'am, not to hold the election.
Okay. Mm.
Within 90 days from the date of appointment at the cost of the society.
Mm.
Now, my lord, he refers to this authority refers to the letter dated 4/11/25.
The same letter, which has
I
been
think so, my
issued.
lord, because in
But this is a letter addressed to somebody else.
yes, my lord. No, my lord, your
No,
lordship,
same,
at
same,
the
same.
At the footnote, my lord, your lordship will find the copy.
A copy has been given. Mm.
Yes, ma'am. Copy had gone to the Journal Joint Register of Cooperative Societies.
Mm.
Now, my lord, let us go to section 39, section 41(6) first, my lord.
41(6).
Yes. Has your lordship got it?
Yes.
41 within bracket 6.
41(6), yes.
Where a board fails to arrange for holding election before the expiry of the term of the board or delegates, or where there are no directors remaining on board, the registrar shall convene. Now, here is a case, my lord, this violation was not done. I mentioned the last date of last term, my lord, 29, 29. We had time till 29 as stated in paragraph.
Have you given any list of dates?
My lord, I have prepared one. I'll place that. 29(9). Para 5, page 6.
But in your case, there is no list of dates.
My lord?
In your petition, there is no list of dates.
Ascent. List of date is there, my lord, but otherwise they will not let it through. But I'll my lord, prepare a note for me, and that I'll place before your lordship. That will help, man. This is more precise. So at para 5, page 6, your lordship will find that the earlier board of director was supposed to expire on 29/9.
So para 5 you are saying?
Yes, my lord. Para 5, page 6. Has your lordship got it?
Yes, yes, para 5.
So, and we held the meeting on 26/9, so 41(6) cannot come, man.
So you are saying that on to
The election was held, my lord, in the AGM of 26/9.
it was supposed to expire on 29/9.
29.
And you held on, you
26.
you held your election on 26/9/2025. So you are saying that this is within
41(6)
the
will not come.
term of 5 years.
Fine.
Correct. So you are saying that 41(6) will not come. 46(1) will not
Then, my
come.
lord, there is another section, I believe, 39.
So 46, you are saying 41(6) will not come. So you have held the election within time. We have held the
Yes,
election
we
within
have
time.
held the election within time. We had submitted the proceedings in time.
Okay.
But
Now, where is this deeming provision?
well, deeming provision at 45. Minutes of proceedings of meetings.
Yes.
May I read?
Yes.
45(1). Every cooperative society shall record in the minutes books in the official language of its station or in English or in any other language prescribed in the bylaws. Proceedings of every general meeting, delegate general meeting, delegate general body meeting and board meeting, and the names of the members or delegates present there at and shall be confirmed at the same or the next meeting. The proceedings of all general meetings and special general meetings of every cooperative society complete in all respects as provided in the Act and bylaws shall be sent to the registrar within 15 days from the date of completion of such meetings with due acknowledgement. The registrar shall give his approval on the resolutions within 15 days of receipt of the proceedings. If no approval is received within the aforesaid period, the proceedings shall be deemed to have been approved. This is a statutory provision, and by virtue of this, my lord, they have no case, man.
Okay.
And they passed the order on 4/11 and 6/11, 10/11. Now, my lord, I will just want to show, my lord, that it was held on 26/9. I was required to submit it on
26/9 within 15 days.
Within
So
15
you'll have to calculate 15 days from there. So 26/9. So you have sent by
10/10.
10/10.
Yes.
26.
September is 30
10/10.
days.
Hmm.
This within 15 days.
Hmm. And acknowledgement is there.
Yes, ma'am.
Hmm. Correct. So now your case is that, I mean, there is no violation.
There is no
There is
violation.
no violation, and the sections they have quoted, you have
And
pointed
even if
out.
there is violation, assuming, my lord, I am not admitting at all.
Mhm.
And
But deeming provision is also
the
there.
provision is there. They should have passed that order before that. And if everything was done, my lord, under the supervision of the officer, my lord, whether he is appointed as returning officer, observer, I have submitted as observer, my lord.
And that's a, I mean, that's a
But,
fact to be
it is
considered,
there.
because there is an observer, then if there is some infirmities,
Yes, my lord.
he should
He
be
never
the first person to intimate.
Yes.
Now, whether the intimation is there or not, that we'll have to see. I mean,
And
that
no
Mr.
opportunity
Talukdar
is
will say.
given to me. That is also another case. But no, if suppose something is there, you must let me know first.
But that opportunity may not be, I mean, in all cases, I mean, the opportunity.
In that case, my lord, they should have passed that order within that 15 days.
No, that section is there. 45 is
That is
there.
the timeline.
Correct. Let me hear him then. That's all, ma'am. You have any?
I would like to place some,
Yes.
let him submit, then I'll reply, my lord, short reply, and then I'll place some citations.
Okay. Or you can give the cases now only. Or you want to give it, okay, fine. Then let him submit. Let him
I
submit.
have to reply, I do not know.
But yeah, the points you have argued, you can support your points with your case laws. Anyways, then. Yes, Mr. Talukdar.
May I please, Your Lordship?
So first of all, I mean, you show us that, like, where is the violation?
Yes, my lord, correct. My lord, on merit.
See, another thing, like, you'll have to address this code. Initially, the notice was given on 4/11. There you have taken a ground of three sections you have pointed out.
Correct.
That there are violations of these sections. And ultimately, then when this one-man person was appointed by the joint register, then he took a different ground.
Correct.
Correct.
I will.
He took a different ground. He didn't mention anything about the grounds that has been mentioned by the deputy registrar.
Correct.
So whether that can be done.
That is a valid point, my lord.
Hmm.
I'll address to that. My lord, in fact, this is one of the ground. My lord, on merit, my lord, eventually, the entire case will boil down to one place, my lord. Whether or not, my lord, in the adjourned meeting, there was quorum. Section 34 makes it mandatory. 10% of the, my lord, members has to be present. So if the case of the petitioner is that on the adjourned meeting also, there was no quorum, my lord, he has no case at all. This is a mandatory requirement. And
No.
it is the admitted fact,
No, the adjournment, on 19, the adjournment happened.
my lord.
First adjournment happened,
Correct.
right? On 19, they said that there was no quorum.
No quorum.
That's why the meeting was adjourned.
Yes.
Then it was intimated to the registry.
Yes.
Then registry, it was intimated and they have given a different date.
In fact, under the act, my lord, there is a requirement how, my lord, one has to hold a, my lord, adjourned meeting.
After adjournment,
Yes.
how the new meeting will be held.
Yes, my lord, I don't say on that. Procedural part, let us assume procedural part is correct. But on the adjourned meeting, on the date of the adjourned meeting, whether there was a quorum, admittedly, there was no quorum at all.
In
And
the
this is-
in the adjourned meeting.
Yes, correct.
The meeting was adjourned only because the quorum was not there. Election didn't have happened at that date.
My lord, the interpretation of section 34 by this honorable court, as well as, my lord, being upheld by the division bench, on the next date also, The 10% is, my lord, mandatory.
Yes.
Because otherwise,
So they'll have to say that 10% is there.
they have to say,
Yes.
my lord, it is a admitted position. They say 10% was not there. They say, my lord, this is an admitted position.
34-3 is otherwise, man. Adjourn meeting.
That is the entire case, my lord.
No, no, no.
34
See,
three
there are
is
two things.
very clear,
No,
man.
no, no. The first meeting, they said there is no quorum. That's why they have adjourned it.
Yes,
In the second meeting on 26, whether they have said that there is no quorum.
they have said that.
They have said that no quorum,
No
but
quorum.
we'll
In
select
50
it.
meetings, no quorum.
But we'll select it.
Yes. This is the entire case, my lord. It's a mandatory requirement. Your
But
lordship.
what about 45?
My lord?
What about 45,
No,
section 45?
45 in the meantime, my lord, the observer report comes in between.
Mm.
Now, the entire matter is sub judice, my lord. Rather, I would say, the deputy registrar is in session of the matter. He has taken cognizance.
No, he
that
has taken cognizance,
Yes.
right? But like he didn't pass the order in
No,
time.
no, the order may not be passed within 15 days because
Why?
your lordship will see.
Why?
Yes, the answer is, my lord, the section 45 is a deeming provision. And this provision has been interpreted only to expedite so that non-approval does not come in the way of the functioning of the society.
Correct.
Now, the moment the registrar receives a report that there is anomaly, the procedure laid down by the act is not followed, my lord, then he can make an inquiry that expiry of 15 days, my lord, in my humble submission, my lord, would not render the order passed subsequently invalid order. Because it is his duty to supervise whether the provisions has been followed or not. Now, once it comes to his notice, because your lordship will see 9,000 members and the requirement is 900. The members present admittedly were 90, my lord.
90.
Yes. 90 members cannot, my lord, adopt a resolution, my lord. So if this is, my lord, in fact, made a directive or it is made liberal, then some members tomorrow will, my lord, assemble here and take any decision.
So you are saying that on 26 also there was no quorum, only 90 members present?
Yes, my lord. And your lordship will, my lord, it is on record. I take your lordships, my lord, to my, not even 90, my lord, 87 shareholders. If your lordship comes to page 60, my lord, my my affidavit in opposition, para 15. I'm
Yes.
reading it out.
Page 60.
60, my lord. My affidavit in opposition, my lord.
Yes, page 60.
Yes, para 15, my lord.
Yes,
My lord, I'm reading out 15, my lord.
yes.
That as regards the statements made in para 14 of the writ petition, the answering respondent, while denying the contention of the petitioner, states that the said society in question has violated section 34 of the said Act of 2007. It is submitted that a valid quorum, 10% of the shareholders should be required, i.e. out of 9416 numbers of total shareholders of the society in question, 942 numbers should be required for valid quorum. But as per the proceeding of the AGM submitted on 26/9/25, only 87 shareholders were found to be present. Therefore, in the instant case, the society in question failed to meet the requirement of valid quorum, and thereby the proceeding thereof has no validity in the eye of law. Now, if your lordship sees how they have responded to this paragraph 15, I take your lordship to the reply filed by the petitioner, my lord. Now, your lordship may come to page 71.
Yes.
Para 15, my lord, again. That as regards the statements made in para 15 of the affidavit, the deponent states that the same are also incorrect and without any basis, and as such denied by the deponent being perverse to records. As regards the allegation of violation of section 34(3) of the Act of 2007 is concerned, it is stated that since AGM of 26/9 was a duly notified adjourned meeting, the law does not provide for any quorum, and there is no question of presence of 942 numbers of shareholders, which is irrelevant. As such, the deponent denies such allegation and also reiterates and reforms the statements made in para 14 of the writ petition. Now, he does not say that on the adjourned meeting, my lord, the quorum was achieved. So, entire case rests on this point, madam. This is an admitted fact that there was no quorum at all.
Where is the report of your this thing?
Yes, my lord. This report is sent on, my lord, 13th, before expiry of 15 days, my lord. And reference of 34 is there. There was no quorum at all. Counting 15 days, my lord, even from the AGM, it is before expiry of 15 days.
Okay, this has come on, this was issued on 13th,
13, man.
and you have passed the order on 4th.
Yes. It is subsequently, but my lord, this particular report has come in between. And the register was already in session of the matter that there was, my lord, no quorum at all.
So it came within 15 days.
Yes, my lord, yes.
But only thing is that like the registrar has delayed a bit.
Delayed.
Delayed
But
a
that
bit.
delay, in my respectful submission, will not, my lord, vitiate the order. Otherwise, my lord, if your lordship interferes in the matter, then it is amounting to frustrate, my lord, the mandatory provision of 34, which they cannot do at all. Because that will amount to give a rider to some of the members. Even tomorrow, 10 members will sit, my lord, and take a decision. They will adjourn a meeting. They will again, my lord, hold it on the next date and take any decision, my lord, which may be detrimental to the society or the shareholders fund. And the division bench has upheld, my lord. In one case, my lord, there was an approval. In the adjourned meeting, my lord, there was no quorum. That was misinterpreted by the deputy registrar and the approval was given. Then, my lord, they have challenged before the learned single judge. Single judge has interfered with, my lord. That was put to challenge before the division bench. Division bench has upheld, my lord, the order of the learned single judge. That even, my lord, on the adjourned meeting, quorum is necessary. 34(1) says 10%, my lord, is a must.
That is a mandate of the statute.
Exactly, my lord.
Mandate of the-
Otherwise, my lord, the requirement of quorum would be made redundant. The provision will be, my lord, defeated. And, my lord, this merit will come, my lord, on the second, my lord, part. Your lordship, at the very inception, has rightly put, my lord, the question, how, my lord, the petitioners are aggrieved. Because your lordship will see, petitioner number 1 is the society. Society cannot be aggrieved of. What board comes, whether A board comes, B board comes, society cannot be aggrieved. Now, petitioner number 2, my lord, apparently he is the chief executive.
Yes.
Now, if your lordship comes
He's
to
none, his name is not there in the list.
no, my lord, he is not a contesting candidate.
And he's not a board of directors.
Absolutely. If your lordship comes to 49, section 49, my lord, who is the chief executive?
Yes,
Lordship has got it, my lord.
yes, yes.
49(1)(a), there shall be a chief executive by whatever definition called of every cooperative society to be appointed by the board or by the state government. In the event of appointment of the chief executive by the board, he shall be a full-time employee of the society. My lord, he is an employee. So the question is, how come he is aggrieved? Now, his approach before this honorable court also raised this question, my lord, his bona fide. He wants that board, my lord. Why he wants that board?
Correct.
To come to the office. This raises his bona fide, my lord. Had the, my lord, contesting candidates approached your lordships, my lord, one could have understood that they are genuinely, my lord, aggrieved by the my lord, disapproval or non-approval. But the petitioners, my lord, they cannot be aggrieved of the, my lord, non-approval.
No, he's simply an employee there. I mean,
Absolutely
simply
correct, my
employee
lord.
there.
Absolutely
How he
correct.
is aggrieved?
Yes, my lord. And this writ petition is not maintainable, my lord. On this count itself, without going to the merit, my lord, it's liable
You
to
have
be.
taken the ground, maintainability.
In fact, my lord, I have not taken. Yes, I have not taken. I fairly submit, my lord. But this is a point of law, so I can take at any point of time. Because facts are not, my lord, relatable to this question, my lord. Admittedly, my lord, he is not the participant.
No, that's why the very initially,
Exactly, my lord.
we have
Exactly.
asked, this court has asked.
And this is the pertinent question, whether it's maintainable, my lord. Because legal injury has to be, my lord, averred in the writ petition. And I do not find any, my lord, averment that this non-approval, my lord, has infringed any of the legal or fundamental right. There is no averment in the, my lord, writ petition. How they are aggrieved? Whether there is any infraction of legal right? No, nothing, my lord. And these are subtle proposition of law, my lord. I am not required to place any judgment. Unless there is a violation of legal or fundamental right, you cannot invoke, my lord, 226. So on the ground of maintainability, with all respect, my lord, this writ petition goes, my lord, fails. And if your lordship enters into merit, I can place the division bench judgment also, saying that if there is no quorum, then my lord, the entire meeting vitiates.
Please place
Yes.
those cases.
এখন দিদি বস্তু
This court is new to this cooperative societies and all.
দি টেপিলৰ নম্বৰটো আপোনাক দিব পাৰিম মই। দি টেপিলৰ নম্বৰটো আপুনি লিখি লওক। ৰিট এপিল 348 of the 23। জাজমেণ্টৰ ডেট হৈছে আপোনাৰ 19/10/23। এইটো ডিভিজন বেঞ্চে দিছে হা। চিফ আৰু কোনোবা আছে? এই কোঅপাৰেটিভ বেংক।
Okay. This is right. I'll require this. I mean, what is to be done with this? Should I keep it?
Your lordship can, lordship can.
So it will be marked, it will be made a part of the, record.
Yes, yes, lordship can make it part of the records.
This is not original, no?
In fact, this has been transmitted to me
Oh.
by the deputy registrar. Your lordship can make it part of the records.
Will make it part of the
Yes,
records.
yes, correct.
And in the merit, you have stated that 34, already you have stated that there is a maintainability aspect we'll look into.
Yes.
And then this 34, you're saying that like, there is a specific
34, my
violation.
lord, is admitted.
Hmm.
34 is admitted. They also say
Hmm.
there was no quorum, there was no 10%, only 87 members.
Hmm.
That is admitted, there is no dispute, my lord.
Hmm.
So there is apparently and admittedly there is violation of 34. So how come, my lord, the proceedings?
So
could have been-
second, the only thing is that a deeming provision, they are saying like that cannot debar him, right? I mean,
Yes.
like that cannot debar him if there is an illegality done.
Absolutely.
Then like only because the deeming provision is there, that cannot debar you.
Yes,
From passing passing a corrective order.
correct, my lord.
Okay.
Because if your
Hmm.
lordship is the entire scheme,
Hmm.
register is, my lord, invested with the corrective and supervisory power.
Hmm.
If 45 is pressed into, my lord, to that extent, the all other provisions, my lord, will become redundant. His supervisory power, his corrective power, my lord, will become redundant. If it is, my lord, pressed into that extent, that 15 days is expired, so now the disapproval has become, my lord, illegal.
If there is a statutory violation also, only because the deeming provision is there, this is correct.
Absolutely correct, my lord. That cannot be, my lord. Such an interpretation, my lord, would defeat the purpose and object of the act.
Yes.
And my lord, so far as the last query, your lordships, my lord, has put the query
Mm.
with regard to the last order,
Yes.
page 53.
Yes.
My lord, I admit that there is a misnomer. Section 39 could not have been, my lord, incorporated herein.
Mm.
Page 53. My lord, he has referred to section 39. But if you read the entire order, your lordship will find that this particular order is based on the earlier order by the deputy registrar. Because it starts with, my lord, whereas it is reported by the district deputy registrar, so and so, so and so. 4th November 25. This 4th November 25, my lord, order was sent to him also. It was marked to him also. Your lordship has seen
Yes.
in the bottom. So this particular order of the deputy registrar has been taken into account while passing this order by the, my lord, zonal registrar.
Only thing is that, he has drafted it very responsibly.
Correct, my
I
lord.
mean, one thing is that like they say it has stipulated time. I mean, there is no, dispute about that.
Yes, correct.
Time is not a dispute.
Yes,
So
no.
he has quoted time.
Yes, correct.
That-
But my lord, my humble submission is, my lord, in fact, this reference of section 39 may not invalidate this order because unless, my lord, the petitioner says that there is no source of power to issue this order. If there is a source of power, the reference of a wrong provision, my lord, will not invalidate the order. Your lordship is aware Sangeeta Theatre, 2000, my lord, 3 SCC.
You have the citation?
I can give the citation, my lord.
You please-
I'll give it, my lord. The correct citation, I'll give it, the page, along with page number.
What was the case? Sangeeta?
Sangeeta Theatre, my lord.
Ah,
Your lordship is aware Sangeeta Theatre.
please give this.
Yes,
this
correct.
citation.
I'll give it, my lord. So therefore, my lord, my humble submission is 41(6), my lord, is exercised when there is any violation, when there is non-approval of the AGM, because for a period of 3 months, the society has to be run, my lord. And in this 3 months, the election is held. Again, my lord, the function, entire office is entrusted to the newly, my lord, elected board. So that is why 41(6), my lord. In the entire provisions of the scheme, 41(6) is invoked for this purpose. A departmental officer is appointed for 3 months. Your lordship has seen, my lord.
No, only
41(6).
because of the stay.
90 days.
Because stay is going on, so nothing
Yes.
could be done.
Correct, my lord.
He's still running the show.
He is running the show, my lord.
It is running the show, man. It is being run without a board, man.
Yes, that is
Petitioner
permitted
not
under,
running the
that
show,
is
not the
permitted.
board is running the show. There is no election, my lord.
That is permitted. He
There
will
is
hold the
no
election.
fun involved, my lord.
Okay, anything else, Mr. Alundra?
These are my humble submissions, my lord.
You give me this Sangeeta case.
Sangeeta case.
Sangeeta's case, then you have referred to this
Division bench judgment, my
division
lord.
bench.
Yes. In fact, this division bench judgment, my lord,
That I have seen, I mean,
yes.
they have clearly held this.
This single judge judgment, my lord, is also reported in 2023 Supreme Gauhati 901, Omil Kolita, Omil Kumar Kolita.
2023?
Supreme bracket Gauhati 901, whereat, my lord, wherein it has been held that even on the adjourned meeting, the requirement of 10% cannot be dispensed with. 10% has to be present. And this is
No,
upheld by the division.
that, I could not understand this.
Well.
I mean, adjourned meeting.
Well,
See, the matter was adjourned only because the quorum was not there.
yes.
Then why, I mean, the need of 10% is
Correct, my
required.
lord. The interpretation is done. If your lordship comes to 34.3, it's a very
34.3.
interesting case.
34.3.
3, my lord, yes. The entire, my lord, issue hinges upon, my lord, 34.3.
Yes.
Well, this is discussed, my lord, in both the judgments. More
Okay.
particularly in the learned single judge judgment, this has been elaborately discussed.
Okay.
Only I'm just referring to, my lord, this particular point. 34, my lord, 1 says that 10%.
Yes.
34.2 says, if within 1 hour from the time fixed for meeting of the General Assembly, a quorum is not present. So your lordship will mark, my lord, the time, 1 hour.
Perfect, 1 hour, yes.
Then, my lord, the meeting shall be adjourned ordinarily to the same day in the next week at the same time and place.
Okay.
So thereafter, my lord, it is adjourned. Now your lordship will come to 3. This is very interesting. If at any time in a meeting, your lordship kindly take note of, my lord, this expression, in a meeting. So this particular expression has been interpreted. I'm reading out firstly the entire, my lord, section, then I'll come to this, my lord. If at any time in a meeting there is no quorum, the presiding authority shall adjourn it to such time or date as it thinks fit and announce the same at once, and the business set down for the meeting shall be brought forward at the subsequent meeting, whether at such meeting there is quorum or not. Now, my lord, apparently, my lord, at the first blush, it appears that at the adjourned meeting, my lord,
The quorum is not
no
required.
quorum is required. Yes. But if your lordship sees, the sentence starts as, if at any time in a meeting, this particular expression means, my lord, that when the meeting is adjourned on the next date, there has to be a meeting, my lord. So, when on the first date,
So what is the meaning of meeting?
meeting, my lord, here, meeting here, what it says.
Meeting is
within-
defined.
If within 1 year from the, if within 1 hour from the time fixed for the meeting of the General Assembly, a quorum is not present. Now, 34.2.
See, meeting can be with or without quorum, right?
Yes, yes.
But for a meeting to be effective,
Yes.
then there has to be a quorum. I mean, if there is a prescribed quorum.
Yes, ma'am.
Now, whether a meeting is defined here, nothing.
No, what, my lord, what is interpreted is, 34.2 says
Mm.
that if within 1 hour,
Mm.
if there is no meeting,
There is
without quorum,
no quorum.
yes. Now, it is interpreted in this way that normally, or sometimes it happens that within 1 hour, my lord, there is a quorum.
After
Meeting is-
after 1 hour, the
Within
quorum
1
is
hour, within 1 hour, there is a quorum.
Then it's fine.
Meeting is going on,
Going on.
but in the midway through, for some reason, my lord, the meeting is abandoned.
Because there was no quorum. Somebody has left or what?
Somebody has left. Quorum has decreased, my lord. So meeting is again fixed on the next day. So
Hey,
this
that-
is the,
this quorum has to be calculated when? At the beginning of the meeting, right?
within 1 hour. Within 1 hour, my lord.
Within one
Yes.
hour of the starting of the meeting.
Yes, correct, my lord. What I'm trying to say, subsection 3 has to be read with subsection 2 conjointly. Then, my lord, the subsection 3 becomes clear. Subsection 3 refers to that, my lord, situation when on the first day there was a quorum, but eventually, my lord, the quorum decreased. Quorum falls. And for some reason, my lord, that has been adjourned. So, under such circumstances, my lord, there will be no quorum, no requirement of quorum under 34.3. This is what has been held, my lord.
So that's why you have been arguing that there was no quorum in the initial meeting also.
Yes, my lord.
That was your argument.
Exactly, my lord. And this is their admitted position, my lord. In the first meeting also, there was no quorum. Had they said, in the first meeting, there was a quorum, then, my lord, there is no requirement of the quorum in the adjourned meeting. And this has been interpreted, my lord, by this honorable court, being upheld by the, my lord, division bench in the Tamil Kumar's case, my lord. If 3 is read independently, my lord, then the understanding would be different. If there is a conjoined reading, my lord, 2 and 3, then it becomes very clear.
But whether there is a requirement of reading both together.
Because otherwise, my lord, subsection 1 will become redundant, my lord. And this, my lord, in fact, it has been noticed in the judgment that the legislature, my lord, will not enact a provision without there being any requirement. 10%, my lord, the presence of 10% will eventually, my lord, it will become odious and redundant.
Okay, now what does the case say? That you said the division bench has interpreted this case.
Yes.
Anil Kumar Kalika?
Yes.
Let's see, like which are the paragraph?
Yes, I'm reading it out, my lord.
I just went, browsed through, then
Yes.
let us see, because this was, 3 is little bit, this thing is there.
My lord, if your lordship reads, my lord, from para 4 of the judgment, the factual background is, my lord, narrated. If you start from para 4, then it will be, my lord, more convenient.
Yes.
The brief factual background relevant and essential for disposal of the appeal are noted here and below. The tenure of the Board of Directors of Gauhati Cooperative Urban Bank Limited was scheduled to expire in the year 2020. Prior to expiry of the tenure of the board, a notice dated 31/7/20 was issued by the Managing Director of the board, inviting all shareholders members to be present in the 51st AGM of the bank scheduled to be held on 11/9/20 at 11 a.m. at the conference hall of the so-and-so, situated so-and-so, Gauhati. In the very same notice, it was also indicated that if for any unavoidable circumstances, the meeting could not be held, then it could be rescheduled at the same time and same place on 18/9/20. The agenda fixed for discussion in the meeting included a proposal for election, constitution of a new governing body of the bank in terms of the Act of 2007, same election. As per section 34(1) of the Act of 2007, the minimum requisite quorum required to constitute a valid meeting of the AGM is not than 10% of the members eligible to vote at the meeting. The cooperative bank comprised of 4265 shareholders as on 31/3/20. In the meeting convened on 11/9/20, only 22 shareholders were present, presumably because of the prevailing COVID pandemic. Thus, for a valid meeting of the AGM to be constituted, presence of 10% of shareholders, that is 426 members, was essential. The chairman of the bank adjourned the proposed 51st AGM dated 11/9/2020 to be held at the same time, same venue, to discuss the same agenda on 18/9/2020. The respondent number 1 had submitted certain representations to the Deputy Commissioner so-and-so as well as the Police Commissioner so-and-so, flagging the issue that in view of the COVID pandemic and the restrictions imposed thereunder, no permission could be granted for the purpose of convening the AGM on so-and-so. Nonetheless, on 18/9/2020, the meeting of the 51st AGM was purportedly held. The proceedings of the said meeting, which have been enclosed to the writ petition, reflect that only 101 shareholders were present, which is less than 1/4 of the minimum requirement of 426 shareholders, so as to complete the quorum essential to constitute a valid board. Nonetheless, the agenda set out in the notice dated so-and-so was discussed, and the appellants herein were elected as the board of directors of the bank for the period from 20 to 25. The managing director of the bank issued a communication dated so-and-so to the Assistant Registrar of Cooperative Societies seeking approval of the 51st AGM of the bank held on 18/9/20. The Assistant Registrar accorded approval to the said minutes by communication dated so-and-so, upon which the respondent one, being the shareholders, preferred the caption writ petition for assailing the minutes dated 18/9/20 as well as the approval thereof by the Assistant Registrar of Cooperative Societies. The learned single judge, after considering the submissions of the learned counsel for the parties, the pleadings filed on record and the statutory provisions, proceeded to interpret the provisions of section 9, 3 and 34 of the Act of 2007 and concluded that the subsequent AGM held on 18/9/20, wherein resolution was adopted electing the respondent numbers 11 to 24 as board of directors of the board for the period from so-and-so, did not constitute a valid meeting because the requirement of having 10% of the shareholders to be present to constitute the quorum for a valid AGM was not complied, and consequently, the resolution adopted in the AGM held on 18/9/2020 were quashed, and the Registrar of Cooperative Society was directed to take follow-up action in terms of section 41(6). Here also 41(6) is involved, my lord, of the Act of 2007. The judgment dated 25/8/23 rendered by the learned single judge is subjected to challenge at the instance of the cooperative bank, the chairman and the board of directors, who were the respondent numbers 8, 9 and 10 in the writ petition. Heard so-and-so, so-and-so. Then, my lord, we can come to the operative part of the reasoning of the, my lord, the Honorable Division Bench. Your lordship may skip to para 20, my lord.
Para 12.
12, my lord. The short controversy posed for adjudication in this appeal is as to whether the subsequent meeting held on 18/9/2020 constituted a valid AGM entitled to transact the business set down for discussion in the earlier meeting dated 11/9/20. The mandate to limit the discussion of business to the agenda fixed in the earlier meeting is stipulated in subsections 3 and 4 of section 34 of the Act of 2007. The opening words of subsection 3 give a clear indication that it caters to a situation wherein during the course of a meeting, the quorum falls below the requirement of 10%, in which situation the presiding authority would be required to adjourn the meeting and to carry forward the very same business to be transacted at the subsequent meeting to be fixed. In such a situation, the subsequent meeting can be held to discuss the very business fixed for discussion in the earlier meeting, irrespective of quorum. However, subsection 2 deals with a situation wherein the quorum is not present at the very inception of the meeting of the General Assembly and is not completed within an hour of commencement of the meeting, in which situation the meeting would be adjourned without any requirement that the subsequent meeting would be held to discuss the same business. Clearly thus, if there is no quorum at the beginning and within 1 hour of the proposed AGM, the meeting cannot be said to have commenced. The learned single judge analyzed the provisions of section 34 of the Act in the following manner. Then we can skip to para 14. Having considered and analyzed the statutory provisions in context of the facts of the case at hand, we are of the firm view that on the first date fixed for AGM, that is 11/9/20, since only 22 shareholders were present, quorum for constituting a valid AGM was not completed, and hence the said meeting was not an AGM in the eye of law. In the meeting dated 18/9/20, only 101 shareholders were present out of 4265 shareholders entitled to vote, and thus the meeting held on 18/9/2020 could also not be said to be a meeting of the General Assembly of the bank. As a consequence, the resolutions adopted therein and the approval given to the such resolutions by the Assistant Registrar of Cooperative Societies are invalid in the eye of law and were rightly interfered with by the learned single judge. Resultantly, we find no reason to interfere with the judgment passed by the learned single judge in so-and-so. So therefore, the quorum would be not required if in the first meeting.
Then like say, then Mr. Talukdar, what is the purpose of adjourning it? See, I mean, if you say that after 1 hour of the meeting, the quorum falls down and the meeting is adjourned. But on the next date, if the quorum is there or not, the meeting is there, then what is the point of adjourning it and what is the object of it?
My lord, because when on the first occasion, when the quorum is achieved, then on the subsequent date, my lord, it has to be, my lord, understood that the quorum is already there.
That is why, then what is the point of adjourning it? That's what I'm asking you. I mean, I understand there is some interpretation. I'll have to go deeply into this.
Yes.
But you to answer me one thing. See, there is a quorum.
Yes,
There was a meeting and the quorum was there.
yes.
And while the meeting was going on, the quorum has fallen down.
My lord,
Now there was no quorum. They realized there is no quorum.
Right.
So they adjourned it.
yes,
Now they take it to a different date.
subsequent date.
And in the subsequent date, there is whether quorum or not, the meeting is held.
No, my lord.
Held to be held to be valid.
Yes.
Listen,
Correct.
held to be valid.
My lord.
Now, then what is the object of adjourning it then see, the
Correct.
purpose will be same.
I understand.
That means like the first meeting, at the inception, quorum was there.
My lord.
So they thought like quorum was there, it has fallen down. We have adjourned it,
Yes.
but the next date, if quorum is there or not, but since that quorum was there at that point of time,
Yes.
we'll go ahead without the quorum also. So what is the purpose fulfilled?
Correct, my lord. The purpose, my lord, with all respect, what I understand, my lord, at the time of adjourning, my lord, there would be an expectation, there would be a presumption that on the next date there would be a quorum. Because that expectation still remains, my lord. On the next date there would be a quorum.
But that,
But if there is no quorum, then the meeting will proceed, my lord. That, my lord, space remains, my lord, for the next date. That there may be a quorum. So that chance is given, my lord, to the shareholders that you please come. You participate. And if they don't come, then, my lord, the meeting will proceed.
But still, I'm little bit
Correct.
this thing.
But
No,
this is
about one thing is that
because
about one thing is that if the meeting is adjourned for lack of quorum, then how can you say that? I mean, how can you say that the adjourned meeting should have had ought to have had the quorum? Then only second meeting you can held it without the quorum.
my lord, what I understand, but this interpretation is only given to save, my lord, or to prevail 34-1. What I understand.
No,
Because
34 one
otherwise,
is clear.
yes,
34
otherwise, my lord,
34 is very
Yes.
clear that like 10% is required.
correct, my lord.
And 2 says that like within 1 hour,
Yes.
if 10% is not there, then it has to be adjourned. Correct?
Right.
If within hour it falls, below 10%, then it will be adjourned.
Correct.
And in the third 3 says that like if on the next meeting, if quorum was there, but the meeting was cancelled because of lack of quorum, but still whether it's a quorum or there is there or not, it can go ahead with the meeting.
Yes, my lord,
He says that.
Yes, correct. My lord, what I'm trying to say, the judicial interpretation by the honorable single judge as well as that of the, my lord,
Division bench.
yes, division bench, is only for the purpose to make, my lord, subsection 1 mandatory. Because your lordship will see, if, my lord, the interpretation is otherwise, as I have already submitted, then that will give, my lord, leverage or rider to any shareholders to come, sit, my lord, adjourn a meeting to the next week, and thereafter hold a meeting and take any decision.
That is understood.
Yes. So therefore, to make subsection 1, my lord, mandatory, inflexible, so that, my lord, no hanky-panky can be done.
So in this case, what your argument will be,
Well.
if I have understood you correctly, your argument will be that since the first meeting,
Yes, my lord.
there was no quorum.
No quorum.
So second meeting, without quorum, you could not.
No,
You
in
could not
terms
have
of the
done
division bench judgment, my lord,
You could
because
not
that
have done
division
so.
bench judgment has attained finality,
Hmm.
but so far as my knowledge goes, no, my lord, appeal has been filed before
You
the
could not
Supreme
have
Court.
done so.
Yes,
Because in the first meeting, you have cancelled it for lack of quorum.
yes, my lord.
Quorum.
Yes.
The second meeting, there has to be a quorum.
Quorum, my lord. There has to be
Without,
quorum.
without quorum, you can't
Yes,
do
my
it.
lord. No, correct.
You can't do it.
Yes,
So that is your argument.
yes, man.
But had it been something like hypothetically
Man.
that there was a quorum in the first meeting, but due to certain other reasons, it was cancelled.
Yes.
Then in the second meeting may not be like,
Yes, then, yes, correct. Then with these members, it would have,
without this quorum also, you could have
yes,
selected those board of
correct,
directors.
correct.
So that is your case.
Yes, exactly. And even if your lordship does not go to this merit, on the maintainability, my lord, I've already submitted. How they are affected?
Well,
Where is the legal
For your
injury,
lordship
man?
to
One
write,
second,
well,
one
we can come back at 2 minutes. Because I'd like to
Oh,
give a
it's
reply.
already, okay. Okay, we'll come back at 2.
My lord, my lord.
No, When he has to submit, let him
My
complete.
lord,
my lord.
that one citation your lordship wanted to have,
Yes, yes.
Sangeeta Theatre, my lord,
Yes,
2004,
2004.
12 SCC. Very short judgment, my lord, 278. Your lordship will take note of para 10 only. There are 12, 11, 12 paras. Para
Yeah.
10, my lord, the Honorable Supreme Court says that reference of a wrong section will not invalidate the order if the source of power is, my lord, existing within the four corners of the statute. So here 41(6), my lord, is not disputed. He has the power to dissolve the board. Only 39 is wrongly quoted. And if your lordship, my lord, peruses the order, your lordship will find it is based on the letter of the DRCS, Deputy Register, that 34 so and so were not, my lord, complied with. So therefore, essentially, my lord, fundamentally that order, subsequent order, does not suffer from any infirmity, my lord. Only there is a wrong quotation, my lord. This is my respectful submission, my lord.
Correct.
So firstly, on preliminary ground, my lord, that this is not maintainable. The petitioners, my lord, have not averred.
Maintainability, you have any citizens?
I have one, my lord, that I can give.
You can,
Yes.
please pass it on to him.
Yes, my lord, these are very good judgment which says that there has to be legal injury.
Correct. That, I
Without
mean,
legal injury, your
it will
lordship.
be a ready reference for me.
Yes, yes.
So like, you can,
Correct,
you
man.
can
I'll give the
pass it.
judgment, man. Yes. Obliged.
Wait, please, your lordship.
Yes, yeah, you can reply on this
This will be a
maintainability first.
Short reply, my lord, and then I'll place the citations that are reliance.
Yes.
So number one, my lord, I have gone through this judgment copy, my lord. Now, this will not be relevant for the purpose, at least for the purpose of decision on, in this case, because I am relying on section 45. They may have a case, my lord, assuming since division bench judgment is standing there. It
So
is
you are basically relying on 45, that
definitely,
deeming
my-
section.
that is the mandate of law.
Hmm.
And it says, my lord, that if that 15 days time is over, my lord, then it has to be considered that deemed approval is received, man. My lord, may I just read it out, that line once again, man. Page 41 of this book, my lord. 45.
Yes.
Every cooperative society, 45(1).
Yes.
Every cooperative society shall record in the minutes books in the official language of its station or in English or in any other language prescribed in the bylaws, proceedings of every general meeting, delegate general body meeting and board meeting, and the names of the members of delegates present there at and shall be confirmed at the same or the next meeting. The proceedings of all general meetings and special general meeting of every cooperative society complete in all respects as provided in the Act and bylaws shall be sent to the registrar within 15 days from the date of completion of such meeting with due acknowledgement. Your lordship will kindly note. The registrar shall give his approval on the resolutions within 15 days of receipt of the proceedings. This is very clear, man. If no approval is received within the aforesaid period, the proceeding shall be deemed to have been approved. He refers to an internal communication. That a report, my lord, I do not know, my lord, I am not privy to it. Whether that is an internal communication, my lord, we shouldn't be concerned with that, my lord. My lord, because it is the cumulative action of the Register of Cooperative Society, not some internal communication, some my lord, inquiry report or whatever, my lord, been sent to the OMUC within that 15 days. The provision doesn't speak of that. It doesn't provide that. It says either way, you reject or you approve, you do it within that timeline of 15 days, or failing which, my lord, the deeming provision will be will come to play. So that is one, my lord. Number, my lord, next, my lord.
So you have any judgment on this deeming provision?
My lord, that no, I have got some other citations, but that I will place. I can place it. Deeming provision. The mandate of law, my lord, is provided specifically. And number two, my lord, on the maintainability point, my lord, the managing director, he is one of the directors, but may be appointed, and he is appointed, he was appointed not by this board, but a board. He was appointed by the board. He is the managing director of the board of directors. Everything is done through him only. Now, my lord, he comes here why? Because, my lord, without a board, my lord, no policy, how he is, my lord, affected, my lord. He cannot take any policy decision by himself. Except the routine activities, cannot do that. He cannot provide increment to the employees, man, or for that matter, my lord, bonus to the shareholders. Then, my lord, in fact, no such important, any such important decision cannot be taken by him unless the board is there, and thereby
The other person has already been appointed.
my lord,
A person who is competent to take decision has already been appointed.
my lord, his the duty given to him is to hold that election, my lord. That is his primary this thing, man. Policy
But
decision he will not take, man.
But in the meantime, he can take decisions. There is
But-
no bar in that.
My lord, in the policy decision will be taken by the
See,
society.
that 40, which is that power 46(1) or
41(6), my lord.
41(6).
41.
Yes.
So 41(6) gives a power to, dissolve it if there is some infirmities and a person can be appointed, right? An interim person, this thing board can be constituted or a person can be appointed. And 41(6), what is the language?
Yes, Lordship is absolutely correct. 41(6), last two lines.
Hmm.
The officers so appointed
Hmm.
shall perform all functions of the board
Correct.
during the said period of 90 days at the cost of the society. Lordship is absolutely correct. He will exercise the power of the board,
Hmm.
all functions.
In practice, my lord, let it be out of record. In practice, my lord, such officers are appointed, my lord, over, my lord, 2, 3, 4 societies, my lord, situated at different places, my lord. My friend will definitely know, man. And they have hardly any time to come attend office, man. How will they take policy decision, man? But anyway, my lord, that apart, my lord, I'm relying on the deeming provision, my lord, that deemed approval.
So the officers who appointed, he
Well,
has the power.
My lord, if the deemed approval is, my lord, there, my lord, 45, then, my lord, these things will not come, man.
The maintainability,
My lord,
maintainability.
no, maintainable, I have said, my lord, that why the.
How he
the-
is affected? See, a person can come to the court in a jurisdiction
My lord,
only when his fundamental rights, his constitutional rights,
my lord, I fully agree. I fully,
any of these, or any territorial rights
My lord.
which are being violated.
my lord.
But how this person's, which of this, which is that right that has been violated by this order of the joint register,
My lord.
which is his right. He is right only to perform as per the directions of the board.
Right.
Correct? He has been appointed by the board. Now, how he is affected and how he can represent this society?
But
Yeah,
he can represent the
see,
society, but
see.
by the action, my lord, he can represent the society, maybe the managing director, my lord.
Mm.
But only thing, my lord, your lordship says how he is affected by the order, this order. Now,
How
my
he is
answer to that is that, my lord, since the cancellation of the, or the dissolution of the board is illegal, my lord. So therefore, my lord, he can definitely come, my lord. If that board comes immediately, there is no point to call for that order itself is void, my lord. On the face of it, my lord.
No, is it this order, whichever is passed, that has been passed with the right or wrongly, that will be
My lord,
decided
my
by
lord,
the,
if it is,
no,
my
that
lord,
will be
expressly-
that will be
if-
decided by the court. And whether he can, whether he, he has any, his right has not been violated in this case. None of his right has been violated. He is appointed by the board. He is a managing director. He'll be a managing director. He'll perform his duties. And for the
my lord,
board,
he cannot
the-
continue to
for
perform his
the-
duties except the routine
no,
duties.
for the board,
My
for the scope of the work, which is
My-
usually, performs by the scope, scope of the work, which is usually performs by the board, that will be performed by this person which has been legally appointed.
My lord,
Now, legally appointed or not legally appointed, that is before this court. That is a
yes,
different
yes,
thing.
ma'am.
That is a different thing. But whether he can challenge this,
My lord, only
My lord,
one correction.
now that,
One correction. My learned senior friend has says managing director. He's not a managing director.
He is
Each
chief
and every
executive.
letter, he has, my lord, represent as chief executive
Chief
officer.
executive officer is, in
And
other words, is managing director, my
I
lord.
have-
That is the position
I
of
have
government.
already, my lord, pointed out,
Chief
my lord,
executive
chief
officer.
executive officer, section 49.
Yes,
Your lordship has taken note of. Section 49 says he shall be a full-time employee of the society. Section 49(1).
sir, he is appointed, that is an admitted fact, appointed by the board,
No, no,
not this board, some other board, he's an old employee.
See, I mean, I'm not going into that aspect much, but I still have a doubt whether he can represent the society or not.
My lord, now that, my lord, after.
He being an employee, who has given him the power to file a suit or file a case? There has to be a power given to him to represent the society. Who has given him the power?
My lord, that instructions I do not have, but my lord.
No,
you know, he's the
it's a legal point, Mr.
He's
Goswami.
the founder.
See, if it
and
is,
he-
if it is a society, if he is an employee has to be, I mean, given a power to file a case, right? To represent the society. Now, who has given him the power to represent the society? Is there
Well,
any statutory provision which says
Well,
that like if any case is filed against the society,
My lord,
then he will represent the society? Is there? any-
Constitution allows me, my lord, a short time I can place the bylaws of their society, only the bylaws will, my lord, from bylaws it will be clear.
No, I mean,
Bylaws, my lord, I can place.
the bylaws.
That,
I
that,
mean,
that will have, my lord.
see,
that-
if there is a power, then power would have been here only, this 46.
I don't-
49, sorry.
My lord, they should have a bylaws, my lord, I'm sure they have a bylaws, and the bylaws, will definitely have them. Otherwise, section 49 is there, and in the definitions also, my lord, it is provided. Who is a chief executive officer? In definition, my lord. Two, para two. Within
My lord,
bracket AL, 2L, chief executive, as your lordship.
See, his power has been described here.
Now, power is there.
His power has been
Power is
described.
there. Your lordship is correct, my lord.
49
49(2)(I). Your lordship may come to I.
to over.
Yes, that
To
is there.
sue or to be
Be
sued.
sued on
Yeah,
behalf of the
Yes, my lord,
society.
it is there.
That
It
is
can
there.
represent
But
the
the
society.
question would be, how come he is aggrieved of the order? How come he is aggrieved?
Hmm.
What is, my lord, how the legal, my lord, right has been infringed?
That's it. Assess.
That
Yeah,
power
and
is
also,
there.
my lord, in 2L, your lordship may look up, my lord, definition 2L. So that power is with him.
Now, 2I is there. I mean, that power is there.
It's
To be sued and to sue, that is there.
But here the contesting candidate, their election, my lord, has been disapproved. So how come he is aggrieved, my lord?
My lord, board is not there, who will come, my lord? Someone has to come, my lord.
They have to come, my lord. The elected, who have participated, they ought to have come.
সেইটো পাৰে to sue or sue, since it is there. No, সেইটো কথা নহয়, এই কথা কোৱা নাই। And he has not come in the personal capacity, my lord, he is representing the society.
See, two says, what does two say?
But
Let us read two,
my lord,
49(2).
mean, yes, my
The
lord.
chief executive shall be under the general superintendent's direction and control of the board. Correct? And
Yes, ma'am.
exercise the following powers and functions, namely. So ultimately, the board has to give an approval.
Correct.
He cannot independently come.
No, my lord.
He
that-
can sue,
that-
to be
that-
sued and to
yes.
sue. Yes, if board says that society should file a suit,
the
then
only-
society has to file a suit. Now, who will be representing the society?
Now the board is
Then
not-
this person will be representing the society on the approval of the board. Now, since the board has not given any approval,
No,
yeah,
no,
there is no board itself.
Because of the illegal order, the board is not there, man.
Board is not there, board, if board is not there, the
So
power
he-
is not there
he-
with
He
him.
is coming on behalf of the society, my lord.
Now, how can he come?
But two,
See, it's the chief executive officer shall be under the general superintendent's direction and control of the board
That is understood,
and exercise the following powers and functions.
my lord. So two I,
So these are not two different sentences. This is one sentence.
yes, my lord.
Correct. The chief executive shall be under general superintendent's direction and control of the board and exercise the following powers and functions, namely. So without board's approval, how can you do that?
My lord, I do not know, my lord, if their bylaws, my lord, which they have, my lord, can throw light on this, but otherwise, my lord, my humble submission is now, my lord, that, so that,
See, he is an employee of the, Mr.
Very-
Goswami,
very
he is an
correct.
employee of the society.
my lord,
So do you think like any employee,
my
he
lord.
may be the chief executive, but any employee of a society or a company can file a suit independently
No, no, he can-
without being approved by the board?
Normally, my lord, the board is there, now the board is. absent of the board.
Mr. Goswami, that, I mean, the inception of the, I don't know, prima facie, it looks like the inception of the repetition is not correct. I mean, ideally, it should have been the members who have been dissolved, members of the board, they should have approached this.
And he also came here after, my lord, approaching the authority, my lord. He has filed a representation first, only then he has come, which is.
So
which is main-
representation should have been filed by the board members who have been dissolved,
No, my lord.
whose rights have been violated. See, either way, whatever way they have been selected by AGM, correct? So they are the rightful member. They have a right to, they have their powers. So they have the right. So if their right is infringed, they should have approached this court. But in this case, this is not the case. I mean, somebody who is an employee, employee will come under whose this thing approval? There has to be some approval. There is no board now.
There is no board now.
There is no board now. Then
No,
there
my
is.
lord, the being in a position as it is, my lord, I would still submit, my lord, that section 45, my lord, it's a deeming provision. If they have anything at all, my lord, they should have passed those orders before that time given. to
But
them.
this court will go into that matter only when you can satisfy the maintainability part.
No, maintain, my lord, this power is there, to sue or be sued on behalf of the cooperative society. Now, in absence of the board, there is no board, so therefore.
Does it mean that like, he will take all the powers and he will do whatever he wants to do? Is
But-
there any,
No,
how can he do that?
he is not seeking anything for himself, my lord.
No, it's
He is saying this order is bad, my lord, and that he needs a board, my lord, that is all.
no, he needs a board. I mean, there is a person, I mean, which has been legally appointed and who will function, and like within 90 days, he was supposed to have the AGM. But it's only because of you approaching this court
My lord.
that could not be done.
Interim order is.
And that interim order was granted, my lord, on that basis of that 45 actually.
The issue of maintainability was not raised earlier.
My lord, that is at that stage, my lord.
So
Motion-
now
motion-
they have raised it.
motion-
It's a legal point. I
motion
mean,
score.
it's a legal issue. Motion stage, of course, they haven't issued.
My lord, they have also not taken that ground in their affidavit.
No, he has admitted that he hasn't taken it.
My lord, I'd just like to place some decisions, my lord, except on
Yes.
that maintainability, my lord. So legal provision is there, that I is there.
So deeming provision, you can.
Yes, man, that I'll provide. Madam, number one is that Nazir Ahmed's a very well-known case. Man. If something is to be done in a manner provided or not at all, my lord.
What is the citation of Nazir Ahmed?
My lord, I would place this, it was very difficult to find. I can place this. Huh? Huh? I'll provide a copy, my lord. Soon, wait.
Okay.
This is 1936, my lord.
Yes, Privy Council case.
Privy
yes.
Council. Then printed later on, my lord, subsequently in SCC online, from which I am taken this copy. I'll provide a copy. So there, my lord, that is the line, my lord. It is Page 512.
If something has to be done, then
Yes,
it has to
madam.
be done as per
In the
the.
manner provided or not at all.
Mm.
Yes. The rule which applies is a different and not less well recognized rule, namely that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. This is in context of 45, my lord. The RCS, being that Register of Cooperative Societies, my lord, cannot override this mandate of law. He is not given any residuary power or anything of that, or plenary power that he will just ignore the provisions of law. That is one, my lord. Then, my lord, no, I don't know. Then one is, my lord, other cases that 2003 2 SCC, Bhavnagar University. 2003 2 SCC 111. Correct, madam?
What is the name of the part, what are the name of the parties?
Bhavnagar University.
Bhavnagar University.
BHAV Univ
Yes.
versus Palitana Sugar.
Hmm.
The relevant paras are 23 and 25. May I just read out, madam?
Yes.
It is the basic principle of construction of statute that the same should be read as a whole, then chapter by chapter, section by section, and words by words. Recourse to reconstruction or interpretation of statute is necessary when there is ambiguity, obscurity, or inconsistency therein, and not otherwise. An effort must be made to give effect to all parts of the statute, and unless absolutely necessary, no part thereof shall be rendered surpluses or redundant. Then in 25, madam, scope of the legislation on the intention of this legislature cannot be enlarged when the language of the provision is plain and unambiguous. In other words, statutory enactments must ordinarily be construed according to its plain meaning, and no word shall be added, altered, or modified unless it is plainly necessary to do so to prevent a provision from being unintelligible, absurd, unreasonable, unworkable, or totally irreconcilable with the rest of the statute. I'll provide the copies. And my lord, this is old law, my lord, 52 Supreme Court, my lord, which is again, my lord, upheld in number of cases, including Mohinder Singh Gill, my lord. Eight. Huh? Para 8 of Mohinder Singh Gill, my 78 Supreme Court. May I read, no? Small para, not short. Para 8, my lord. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. You will also kindly mark the word. Otherwise, an order bad in the beginning may, by the time it comes to court, on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Bose J in Govardhan Das Bhanji, AR 1952 Supreme Court, 16 Mallet. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the acting and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine becoming better as they grow older. This is in the context of the orders when we are trying to give a new meaning.
But in your case, thing is that like the earlier order was perfectly fine.
My lord?
No,
No, that is not speaking at all, my lord.
There was,
Earlier order, my lord.
there was no addition, there was no supplement.
But there is no, my lord,
Only thing is that there is wrong.
both the orders are absolutely without any grounds, without any reasons, but non-speaking, my lord, on the face of it.
No.
Now by affidavit, And by submissions, my lord, they cannot improve that.
See, they have quoted certain statutory provisions, violation of.
My lord, am I not?
Once,
I am
one-
the
no, no,
agreed-
once statutory provisions have been given, and statutory provisions are very, explanative,
No, my lord, I am the
So-
aggrieved one, my lord.
correct?
But
So,
it's not-
so wha-
Am I
what
not
i-
entitled to the, how did I?
what is there in the statute? They have quoted the statute, the provisions of the statute.
But I have shown, my
So
lord,
what-
that I have not violated those things. And so far as interpretation of 34 will not come because of 45.
That you are arguing,
My lord. That is my. humble
that you are arguing. So your only case is, basically the deeming provision.
submission.
Your main
My lord, my
crux
lord,
of
my-
your argument is
Even
deeming
if
provision.
they have something, my lord, they should have come earlier, my lord. That is my.
So deeming provision is the what you are basically saying,
Right.
that is a statutory provision
Right.
that should not have been violated.
Exactly.
Uh, And by this deeming provision, your,
And their time, my lord, expired on 25, 25/10, on 25/10, because on 10/10 they received the proceedings. So 15 days means 25/10. And they passed or impugned orders on 4/11 and 10/11.
but he made some arguments, you haven't met those
My
arguments.
lord, that will not, my lord, the argument, but that is why I am placed these provisions, man. By filing affidavit and by subsequent submissions, my lord, during the pendency of the matter in court. But that is what is spoken.
No, as far as the deeming provision is concerned, he made some submissions.
No, that power is not given to the RCS, my lord, to override, my lord, if it is illegal. Where is it? My lord, let the statute be placed. Where is the power, my lord? If that be so, my lord, then nothing will work, my lord. Every time we'll go, we have the power, my lord, we can pass this order. The statute will come to a naught. So this is my humble submission, man. And I would like to place something, my lord, if grant me time till tomorrow, my lord, on the.
We'll close this, you can give your case laws here, to the court master.
Yes, ma'am.
Whatever the case laws, you just mark those,
My lord, only that, on maintainability, your lordship, and the deeming provision, sorry, I'm sorry, deeming provision, that I'll give.
if something is there.
And otherwise, my lord, this thing already I had
Mr.
given the-
Talukdar, if you have something on deeming provision or something,
Yes.
or any case laws, then you
I'll
can give it to him.
Yes.
Just mark that
Yes.
paragraph and
Yes.
give this,
Yes.
give the case law.
My lord, only one submission. My learned senior
Mm.
have read one judgment in respect of interpretation of statutes.
Mm.
Lord, what I have understood, those two paragraphs, my lord, is going to help me, my lord. Because what the paragraph
Yes.
says, the statute has to be read as a whole. And by interpretation of one provision, the other provisions cannot be made redundant or, my lord, ineffective.
Mm.
My submission is, if 45 is given effect to and stretched, my lord, to that extent, that other provision.
In your case, what will be, the thing is that, like, that factually it has come,
Yes.
that you have not improvised whatever the
No,
thing.
no,
The
madam.
the original order is there.
Yes, my lord.
Original order is there, you
Yes.
have not improvised
No,
it, or
madam.
you have not added it, or
No.
you have not amended it.
Yes.
Only thing is that you have misquoted a section.
Yes, my lord.
Misquoted a section.
correct.
So whether in that context, in
Yes.
that factual circumstances,
Yes.
the Mohinder Gill Singh Gill will be applicable or not. Mr. Goswami has submitted that Mohinder Gill Singh Gill will be applicable in that circumstance. That's
Lord,
what that is.
Mahinder, if I have rightly understood, Mahinder Singh is in respect of improvement by way of affidavit. My lord, we have not brought any new facts. We have not brought. We have said that 34 is violated. Even if the other provisions are not taken into account, on the ground of 34, my lord, the writ petition fails. Because there is, my lord, mandatory provision. Quorum is mandatory. Division bench has upheld in both the adjourned meetings, my lord. 10% is, my lord, necessary. Only 87%, my lord. Whereas, my lord, 927, my lord, was required to be present. Only 87 are present.
Correct. Now on the deeming provision, he's saying that like deeming provision
My-
is under the statute.
Yes.
Yes.
It's not that there is something which has been, which has to be interpreted.
Yes.
Or inferences has to be brought in.
Yes.
This is a clear cut, totally unambiguous
Yes.
provision.
Yes, my lord.
That there is a deeming provision.
Yes.
Once that time period is over, it is deemed to be approved.
My lord.
So what will be your
My
submission?
respectful submission is,
Mm.
my lord, the
Wait.
deeming provision is for the
Mm.
purpose of expediting, my lord, the functioning of the board.
Mm.
Now, my lord, if a register sits over a particular aspect, my lord, it does not possess any order or does not give effect to, then under such circumstances, my lord, the deeming provision will come into play. That see 15 days have expired, so we will understand that there is an approval on your part. Now, here is a case, my lord, where there is violation of the mandatory requirement. There is no quorum at all. Under such circumstances, when there is a report, the report is by the observer. I have given the, my lord, records. Report is by the observer, saying that there is no quorum. Whether the registrar will shut his eyes, my lord, and only on the count of deeming provision that 15 days has expired, so therefore I will approve it. That will amounting to, my lord, violate the other provisions of the, my lord, Act. All the provisions of the Act. Deeming provision cannot override the mandatory requirement of section 34, my lord. Cannot override. And deeming provision is in respect of other context, my lord, for expediting the functioning of the board.
So you are saying that like, I mean, only because of the deeming provision, you cannot keep your eyes shut and you will
be.
not pass any order.
Yes, my lord.
But his contention is that if any order, I mean, ought to have been passed, then that would that should have been passed within time. That is his, I mean, maybe his contention.
Yes,
is
but
that.
between these 15 days, there is a report, my lord.
No,
There is
that
a
report will cannot be
The
considered.
register is in session.
No,
It was by the
no,
observer.
Mr. Goswami, that report is that report is part
That
of
is
it.
an internal
No,
communication.
that is the duty of the observer. That is the
Observer.
purpose of putting the observer in
No,
a,
man, no, man,
in
I
an election.
understand for whatever, my lord.
So
As if
duty,
it might
see,
not-
Mr. Goswami, a duty has been casted upon the observer.
Very correct.
The observer has to report, and that is kind of, I mean, kind of a statutory report.
My lord, he has reported. He has
Yes.
reported. They have not acted on it within that time, my lord. Am I to suffer for that?
Then, I mean, now who are you to suffer for that?
Yes.
My
How
lord?
is suffering?
You have not suffered.
How is
My
suffering?
lord, that is another aspect, my lord. But then that deeming provision, my lord, thereby because of this, and they can pass order at any point of time. This
Mr.
is not-
Goswami,
I
the
believe, my lord.
problem will be your maintainability. The court is very clear about these things. The problem will be maintainability. So maintainability, I mean, I'll have to, I mean, this court has to satisfy that there
Madam,
is a, this
For
is
this matter, I
maintainable.
rely on that 49, my lord. 49 2I. That I rely, and I'll try to see, my lord, if I can place something excellent. Now, only one thing, my lord. My lord, because of the deeming provision, because of the, my lord, the deemed approval, my lord, this society on 6/11, my lord. Your lordship, that annexure is page 73 to my reply to my friend's affidavit in opposition, my lord.
So you
Eh,
have given representation.
No, we have appointed and I'll read out, my lord, page 73. Running page, my lord.
73.
73,
Yes,
my lord,
yes.
And annexure 8 to my reply affidavit.
Hmm.
There is an intimation to the district deputy registrar of cooperative societies. Submission of the proceedings of first meeting of the newly elected directors to the board. With reference to the subjects mentioned above, I have the honor to submit the proceedings of first meeting of newly elected member to the board.
No, that you have given, yes.
Yes, man. This I have acted, my lord, on the basis of that 45, man. They have held that first meeting and they appointed so and so, and the proceedings is also submitted before the authority.
But the division bench and single bench is
No, no,
already held.
My lord, that will come only if 45. Only then it will come, division bench. That is a different aspect, my lord. There is a division bench judgment, my lord. I cannot say.
The division bench has already interpreted those sections.
If only 45 will not come, in that case.
The 45 comes, yes, the 45.
Only then, my lord. This will be.
So we'll close this, we'll
yes,
close this,
And
we'll close
on
this.
deeming provision, I'll try to find some.
If something is there,
Fine.
something supports your arguments, then like, please
Fine.
give it to the court.
Much
Mr.
obliged, madam.
Talukdar also, if
Well,
there is something,
on the thing.
some material on this.
I'll try.
Okay. Heard Mr.
You-
B.D. Goswami,
You
the learned.
try to find out something again, yeah, I know.
GSM was fairly dim photo.
Now, Mr. Goswami
And
has,
this was
Mr.
the-
Goswami was little bit surprised probably today.
Huh?
Because I don't think you anticipated this maintainability thing.
Yes, correct.
You were a little bit surprised.
No, my lord, there have been cases by managing director earlier, my lord. Even I had filed, my lord. That was.
Anyways, I heard Mr. B.D. Goswami, the learned counsel appearing for the petitioner, also heard Mr. R.K. Talukdar, the learned standing counsel for cooperative department.
Co-person department.
Co-person department first. Hearing concluded.
Yes.
Judgment reserved.
Lordship will make that records part of the
Good.
part of the records. I have handed over your lordship.
Right, Mr. Talukdar has submitted before this court a communication dated 8 April 2026 issued by Deputy Registrar Cooperative Society Sibsagar along with certain annexes, which has been kept on record, marking X.
Much obliged, ma'am. Grateful for.
I'm
the-
deeply obliged for the patient hearing, ma'am.
Step down, right away. The cooperative society is correct account. Independent at TD. At lagi working. লিখিব সময়ত দৰকাৰ হয়।
Well, the affidavits, so far as item number 10, 11, 12 is concerned. Those are ready, my lord.
10, 10 and
10, 11, 12, my lord, the affidavits are ready, we will file it by next week, my lord.
10,
13, my
11
lord,
and 12.
yes, 13 probably,
11, he has already filed the
no, one additional query was raised by the honorable court, so we will file one affidavit there also.
10, 11 and 12.
Yes,
In the 10, 11 and 12, we are going to file an affidavit.
yes, my lord.
And what about 13?
13 will probably covered by all this, my lord, affidavit, same issue, my lord.
But আমার copy দিয়া নাই।
No, no, file it.
Okay.
By
It's
next
being
week we will
filed.
file it.
So
We'll
he needs
serve
some
copy.
time.
Yes.
Only thing is, my lord, Lordship will extend the interim order, my lord.
Yes, I wrote against it. It is not how to do. Sir, no.
My lord,
No, but you have not filed any affidavit as yet, probably.
No, no, no.
You have not filed any affidavit, no.
Millard-
But you say, Mr.
Millard, I-
Bhatti said some affidavit?
I will be 11, he has already.
my lord,
Eleven to the.
my lord, item number 10 and 13 are same.
Yes.
11 and 12 are different, my lord. Therefore, I don't think all this should be tagged together, my lord.
Yes.
10 and 13 is same
Yes.
and 11 and 12 is different. my lord.
10 and 13 same.
No, no, 11 we have not filed affidavit, man.
11, you don't file it. It's there.
Oh, it was আমারই guess.
Affidavit by the excise department, not by taxation.
By,
I am appealing for the taxation department.
Yeah.
We'll file an affidavit. if-
No, he is appealing for taxation department.
This extra-
One affidavit filed by excise in item number 11. Tax is yet to file, we'll file it by next week, madam.
Okay.
They filed it by 2 weeks.
So 10, 11, 12. So what about the segregation? Should be
Yes, my lord,
segregated?
11, 12 are different matters, my lord. In fact, 11 I appear, that's a different matter altogether. I don't think these matters needs to be tagged, my lord. That's what I'm saying. They
Mhm.
may come separately.
So 10 and
10 and 13 are same.
13 are same. Okay, then we'll segregate it,
Yes, yes,
right?
yes.
Then 11, 12 will come together or not?
yes.
11, 12 will come together.
Yes.
Okay. What Mr. K. N. Chaudhary, the learned senior counsel, in item number 10 and 13, no? K. N.
10 and 30, yes.
13 also you are appearing? Mr.
Yes,
K.
yes.
Mm,
Same.
Mr. K. N. Chaudhary in learned senior counsel assisted by so and so.
B. Purohit.
For the petition, for the petitioners, for the petitioner. Also heard Mr. B. Gogoi, the learned standing counsel for tax department. Mr. B. Gogoi submits that he would, that he has received the instructions and he would file an affidavit in the instant case within a short time and please for 2 weeks' time. Prayer is allowed. Full stop. Then you write, Mr. K. N. Chaudhary, learned senior counsel submits that item number, though item number 11, that is, you write the WPC number 3025/2020 and WPC number, item number 12, don't write item numbers, write the WPC numbers, WPC number 2653/2021 are tagged with WPC number 326/2026 and WPC number 1689/2026. The matters are in fact different and the matters should be segregated. To which the parties appearing for the parties the appearing for the other side is have no objection also. In view of the aforesaid, these two matters are segregated from these two matters, that is item number, that is
11
WPC,
and 12.
you write the WPC number 11 and 12 are segregated and to be listed after 2 weeks
Miller.
before appropriate bench. and item number 10 and 13, you write the same thing? That this matter, these two matters will be listed together after 2 weeks? And, and 2 weeks, 2 weeks time is allowed for, for filing the affidavit. That's it.
In the meantime, the interim
In,
order.
in the meantime, the interim order so passed in item number 10 and 11 or all
10
the
and 13.
10 and 13. 10 and 13, you mentioned those 11 also. So 11, 12 also, the interim orders passed. I'll look into it and just correct it. I'll do it.
Deep level.
You put the WPC numbers, don't put the item number as 11, 12. So 11 and 12 will be different, 10 and 13 will be together.
14.
May I pray, Lordship?
Yes,
This case, last occasion, the medical report of the petitioner was called for from the jail authority.
has it been received? I don't think
It
it
is
is
not received, my lord.
They have not sent anything, Lordship, since 11/3/2026 is pending. In page 10, I specifically made some para 11 Lordship. Earlier, Lordship, bail petition was moved before the learned court below, Lordship.
Yes, what has happened, Mr. Sharma? I mean, why this report hasn't come, is it?
My lord, actually, my
It
lord,
was, this order was passed long time back,
Yes, my lord.
22.
yes. My lord,
Whether you
communication,
have communicated or not,
communication was made,
where is the copy of communication?
my lord.
They have inquired about it, they have not received it.
Hmm. My lord,
See, to be very honest, I mean, you have only ground of medical.
Not only medical.
No. This is the court view. You
Yes,
listen to me. The medical ground is the ground wherein this case can be considered. So now the medical report has been sought for, and you are not doing anything.
my lord, kindly, even my lord, short date, my lord, day after, today is my lord, very. On my lord, Monday, my lord, kindly, maybe fix, my lord.
You
I
please get it. You
Mal-
please get it, because this person is supposed to have suffered from
Yes.
many things,
Critically.
and whether he is getting proper treatment or not.
My lord, earlier, my lord, honorable court directed to give proper treatment. That is also.
No, I mean, proper treatment as well as a medical report was not.
Yes,
given.
ma'am. So, my lord,
So medical, this High Court passes an order
my lord,
and jail authority doesn't do anything. That
Mm.
cannot happen, na,
Yes, yes.
Mrs. Sharma. That cannot happen like this.
my lord, short date may be given, my lord, I'll personally, my lord, I'll.
We'll put it on in the next week.
Next week.
And we'll see like what they come up with.
Next week.
Yeah. Heard MSMDV, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state, as well as Mr. U. Chaudhary, the learned MI, the learned counsel appearing for respondent number 2. Wide in order dated 20/2/2026, this court has directed the jail superintendent through the office of the public prosecutor to the jail superintendent to produce a medical report as to the health status of the accused applicant, full stop. However, till date, no such medical report has been sent by the jail superintendent. In view of the aforesaid, it is directed that a medical report of the status of the health of the accused applicant shall be produced before this court without any failure on on 28th, Tuesday, on 28th of,
Can it be on 29?
okay, on 29th of April, 2026. Let the matter be listed on 29th of April. 29th of April will consider. Mr. Sharma, positive.
My lord.
15.
Case there is come.
My lord, it is my lord charge-sheeted matter.
Oh, charges
My
are
lord,
case here has come.
Record, my lord, not called for, maybe called for, my lord, today.
The registry is called for, TCR hasn't come.
Yes, my lord.
TCR hasn't come. It was called for.
Yes.
TCR is yet to be received. Let the matter be listed. Let the matter
I
be.
think in the next item, your lordship calls.
Huh? TCR is there.
In the next item, your lordship, was this? Yes.
Next item to ase. Oh, yes, my, in next item, my lord, TCR
Both
is
are
there.
same, your lordship.
Okay.
Yes,
15 and 16.
yes. TCR is there.
It is second bail application, your lordship, and earlier it was rejected.
Yes.
Yes, 30.
Where is what is the earlier order?
Yes,
Please?
30. Yes.
Page?
Page 30, your lordship, and the relevant part is 32.
Yes.
This time, your lordship, I have come up with new grounds, your lordship, that is page 33.
That ground is gone.
Page 33, your lordship, kindly have.
That ground is gone. 47, 48 complied with. What else you want?
48, your lordship, in earlier occasion, the plea was taken that the notice under sections 47 and 48.
So 47, 48 complied with.
Yes.
Complied.
So I mean now.
I'm not on that part.
What do you want now?
Just 33, your lordship,
Hmm?
kindly. Just 33.
No, you tell me what is your ground.
Just 33, your lordship,
Hmm?
kindly. The
You tell me what is the ground.
Section 36 of the BINS was not.
The 47, 48 complied with. You are aware of this, why you have been arrested. Your family members are aware of this.
Yes,
Then,
notice in earlier occasion, your lordship, it was the plea that the 47.
oh, 47, see, if 47, 47, 48 is not given, then 36 sign is not there, then it's a different thing. But now 47, 48 complied with. You are aware, your family is aware while you have been arrested.
Yes, yes, yes.
Then
Yes, 33, your lordship. That is the 36, your lordship.
30,
Yes, 33.
I know what you want to show me. I am saying that, like, I mean, see, this
In
all this,
arrest memo, your
all this arrest memo 47, 48 issued at the same time. So you were aware,
in earlier bail plea, your lordship, it was not taken.
you were aware that this person has been arrested on this ground and he has been arrested. Arrest memo is for what?
Arrest memo, that's
What
why only
purpose?
in earlier bail petition, your lordship, this plea was not taken.
Now you are taking this plea. I am saying that you are aware that you have been arrested, why you have been arrested, when you have been arrested. You are saying that there is no signature, right?
Yes,
But you are aware of everything. Then how you are given, how you are affected?
but one part is there, your lordship, since the notice under section 47, it was given in English. And the present petitioner, he is an illiterate person, your lordship. The meaning of giving the notice is to make him understand, your lordship.
All drug traffickers are
in that
all
sense-
drug traffickers are illiterate.
But I am not on that part. I am only this part is section 36, your lordship. Yes, 33. Yes, 33, it is in respect of the petition number 1, and 34, this is in respect of the petition number 2. No signature of the arrestee as well as no signature of any independent witnesses.
Yes, Mr. Sharma.
My lord. My lord, my lord, that purpose, my lord, already served.
The purpose is purpose, but there is there is a statutory provision.
Yes, my lord.
Your police officers are I don't want to use any words,
Yes.
but I don't know how they are trained. You have now another department. So in spite of all these things, these are statutory provisions. Section 36 is 36 is a provision which has to be followed while arresting a person. The statutory provision says that a signature is required in the arrest memo. Then why your police officers are not taking it?
And especially in 62 of the BNF also, your lordship. 36 as well as the 62 of the BNF. your lordship. I'm reading the 62, your lordship.
You don't need to read. I know about this.
You have the, my lord, scan copy, my lord. Because the original 36 is there, my lord. I have to.
Mr. Sharma, there are some judgments which have been passed by the coordinate benches, some other coordinate bench, wherein this 47-48 is complied with, and at the same time, at the same time and same place, the arrest memo has been issued. Then whether non-compliance will be violative of the statutory provision, or there are some judgments.
Yes, 50. Have annex one copy. I had annex one copy of the order, your lordship, and it was passed by your lordship. This thing.
But in that case, 47-48 was not there. 47-48 was not issued.
Yes.
But here 47-48 issued.
But the 47-48, although it was issued, but it is not as per.
Hmm?
Your lordship ordered 55.
I will consider this, I'll consider and pass an order. We'll see, what is to be done. In all the cases, same, right?
All these cases.
Only thing is that, see, Mr. A.M. Khan, only thing is that in your case, I have seen this, the signature is not there in the arrest memo. But at the same time, the 47-48 notices were given to you. Correct. So 47 is the grounds of arrest that has been given to you at that spot only. So you were aware why we have been arrested. That object of 36 is little bit different. Object of 36 is if nobody is there, and 48 is also given to you.
Yes.
Correct. So if no one is there, you have been arrested, then somebody should witness that that a person has been arrested. So that is the purpose why this 36 is there. That the signature of a witness would be taken if the family members are not there. If family members are there, his signatures would have been taken. But in this case, whether you will be prejudiced by that, once 47-48 has been given to you at the spot, your family members were there.
But in the instant case, your lordship, I have made a statement that the petitioner, they are the illiterate person, your lordship. Although 47-48 it was given, but it was written in English. It was written in English. So the ground of arrest should be communicated in the language in which he can understand.
He understands what, Manipuri?
No.
A cookie?
Illiterate person, your lordship, in English, how he?
No, he's a cookie or Manipuri?
No.
He's what?
No,
He's a-
Ajizura.
Acha, he's
He is from Kolpai.
That ground not taken, man.
Now,
No.
the purpose of giving notice, your lordship, what I
You have not been communicated.
No.
Why you have been
communicated, your
arrested?
lordship. I am not saying that the communicated, your lordship, but it was communicated in the language which he cannot understand, your lordship.
You were not told why you have been arrested.
But he signed.
You have, but all these things have been.
I means
Yes.
what? Kindly see that.
All these
One-
things have been.
One of the commissioner.
All these narcotics drugs have been seized from you, and you have not been told why you have been arrested.
But kindly see that 47 and 48, your lordship.
47 and 48, the signature of the arrestee, your lordship. kindly see. He is an illiterate person. He is not well acquainted with English. And the notice, it was need to be communicated in the language which he can understand. But this plea was also not taken in earlier. In the earlier occasion, in the earlier bail petition, the plea was only that the notice were not given.
And
Now
in,
36, your lordship.
in this petition also, my lord, death ground is not taken. That language. In para B, it is mentioned, no? Do not understand.
Okay, we'll pass order.
But
We'll pass order.
I'm humbly praying only, your lordship, that the arresting authority has committed illegality.
There is no illegality.
On that sense, your lordship, that
Illegality that has done by you. The materials have been seized from you. What illegality?
materials, your lordship, I am not on
Hmm?
that part. The
Why not that
procedural-
part? Why not that part? You keep on doing trafficking of drugs and you'll say that like illegality.
Procedural
Commercial
part,
quantity.
your lordship. I am only praying, your lordship, since there is lapse on the part of the arresting authority. Since there is lapse on the part of arresting authority at the time of arrest. Only I am praying that to be.
Okay, we'll pass an order. We'll pass an order. I'll just come back in 5 minutes.
Well, Your lordship, the Justice Mitali Thakuria's judgment is general. I will provide medical.
But this court is holding consistently that if 36 is not complied with, there's a violation of statutory provisions. And if there is a violation of statutory provisions, then it cannot be saved. So we'll have to allow them. We'll pass the order. See, if there is a violation of statutory provisions while arresting, then it cannot be saved. It vitiates the whole arrest. So you'll have to take care of your police officers. Is there he has come?
Yes, ma'am. Come.
He was here and Mr. Datta was here.
Rejected by your lordship, second.
Mr. Datta was here only. I think he's somewhere here. Where is Mr. Datta?
Oh, 17. Please come in.
Where is he?
Come in.
Is there what is there?
My lord.
Is there what is there?
Yes, my lord. That 160, the 183 statement, my lord, that is, my lord, they are already looked by your lordship. And
No,
my lord,
updated any updates on that?
update, my lord, that the statement of the, my lord, petitioner.
You see,
My lord.
what is there?
Yes. He admitted, my lord, is a concerning party.
Yes,
My-
Mr. Datta.
My lord, before your lordship goes through the diary, my lord, can I point out, my lord, page 10 for a once?
Page 10.
Page 10 is the FIR, my lord.
Hmm.
Lordship, may kindly see the subject, my lord. Regarding 1 year love relationship with a boy named Kaushik Sarkar, my lord.
Yes.
My lord, the FIR says, my lord, it is an attempt, my lord. I don't want to read it, my lord.
How old the girl is?
29 years. Well, I'm coming, my lord. Well, admittedly, we had a relationship, love relationship, my lord. Now, lordship, may kindly see the date of the FIR, my lord. It's my lord 22/12/25, my lord.
Yes.
22/12/25. Now, your lordship will kindly turn to page 19, my lord, 19, my lord.
Yes.
19, my lord, it is a, my lord, appointment letter, my lord.
That I,
The
yeah.
Kaushik Sarkar, my lord.
Mhm.
So the appointment is of 13th November 2025.
Mm.
Lordship will see it, my lord.
Mm.
Now, lordship, may kindly have a look, my lord, page 3 of my petition, my lord. Page 3 of my petition, paragraph 6, my lord. The facts of the case, my lord, I have narrated, my lord. Page 3, paragraph 6, my lord. So the petitioner begs to state the fact is that admittedly there was a love relationship with the informant since long, but the same could not last long due to some dispute. The love relationship between the petitioner and the informant had broken almost a year and a half back. The petitioner begs to state the petitioner was selected as a graduate teacher science in the provincialized so and so man. Now, paragraph 8, my lord, the petitioner begs to as the petitioner got appointed as graduate teacher science in the district of Morina. The informant got annoyed and filed the present FIR, alleging, my lord, vague allegation against the petitioner.
Why she got annoyed?
My lord, because the love relationship, my lord, was broken, my lord. Now she wants to marry me, my lord. But I am not willing to marry her, my lord, at this stage, my lord.
But you had exploited her.
My lord.
You had exploited her.
My lord, that exploited, my lord, so far, my lord, it seems, my lord, from the FIR, my lord, whenever I gave proposal for, when I get marriage proposal from other places, he breaks up the marriage proposal promising that he would marry me. In fact, my lord, the case is of not marrying me. And in fact, my lord, if your lordship, we approach the court below, my lord.
Okay, Mr. Sharma.
Hello.
Let him go. He's a teacher and like she's a matured lady. She's a matured lady. Let him go. Let him go. Heard Mr. N.J. Dutta, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APB for the state. This is an application under section 482 of BNSS 2023 paying for PRS bail to the accused applicant in connection with Morrigaon PS case number 289/2025 under section 69 and 3 of BNS 2023. An FIR was lodged, next paragraph, an FIR was lodged on 22/12/2025 by the informant alleging that she was in a romantic and physical relationship with the accused applicant for 1 year or so. However, on 21/12/2025 at 2:30 p.m., on receipt of a phone call from the accused applicant, she went with him inside his vehicle, and the accused applicant tried to have forcible sexual intercourse with her. When she denied for the same, he tried to forcibly commit the offense. After receipt of the FIR, the police registered Morrigaon PS case number 289/2025 was registered under the aforementioned sections. A pre-arrest bail application. A pre-arrest bail application, that is AB number 475 of 2026 was earlier filed by the accused applicant, which was rejected. Court. The learned counsel appearing for the petitioner, accused applicant submits that accused applicant has been appointed, was issued an appointment letter for the post of graduate teacher on 13 November 2025. And he has joined,
He has joined, but.
huh?
Right.
And accordingly, he has joined his service, full stop. He further submits that the accused applicant was in a love relationship with the, with the, with the, with the victim girl, and due to certain differences, their relationship could not last, and the same has already been broken off, full stop. He submits that, since he denied, the marriage proposal received from the victim girl with, with a motive of vengeance, has filed the instant FIR. Full stop. He submits that, though there may have been certain, may have been sexual relationship between the two, that is purely consensual and not a forcible one. Therefore, he submits that the victim being a adult lady, and the accused also being involved, in physical relationship, in consensual physical relationship, there is no offense committed by the accused applicant in the instant case. He further submits that, that the accused applicant, being a government employee, he will suffer irreparable loss, which, irreparable loss, and he may have to lose his job in the event of his arrest. Therefore, he prays that, the accused applicant should be granted the privilege of pre-arrest bail, and in the event of granting such bail, the accused applicant shall fully cooperate with the investigation. Full stop. Next paragraph. Per contra, the learned APP appearing for the state opposes the bail application. Case diary in the instant case has been submitted before this court, which has been perused. Full stop. Taking into the entire facts of the matter, and on perusal of the case diary, this court is of the considered opinion that would be granted the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of his arrest by the arresting authority, in connection with Morigam PS case number 289/2025, the accused applicant shall be released on bail on furnishing of a bail bond of rupees 50,000 with a surety of like nature, subject to the following. To the satisfaction, you write, to the satisfaction of the arresting authority, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days from passing of this order. The accused applicant shall fully cooperate with the investigation and make himself available as and when called for. The accused applicant shall not try to influence any of the witnesses which may be connected, to the instant case. In view of the opposite directions, the instant AB application is disposed of as allowed.
I'm offered.
CD to be sent back immediately.
18 orders.
Your Lordship, I'm on behalf of D. Gogoi. He's a standing counsel for PHA. So I am here on his behalf. He is unable to be present today. He's unable to be present today. So he has placed the instruction.
What instructions you have?
Your Lordship, the contempt petition was on the grounds that
See,
non-compliant.
a financial section has been already given.
Financial section already done the, as per my instruction.
Hmm?
As per my instruction, Lordship, on my client, Lordship, the financial already returned the
filed the lordship, as because the financial year has been already closed.
No, it is a new financial, decision 232026.
But they informed that in the new financial year, the last year lordship.
Your lordship, due to a model code of conduct, the a fund is not dispersed, but after that it will be
Hmm?
dispersed. I've been instructed that due to model code of conduct is going on right now, so the fund will be dispersed thereafter. After.
Yeah, we'll put it up some other date. Let them come up with this thing. Right, the parties are duly represented. Let the matter be listed after 3 weeks. Let this model code of conduct be over, then financial section already been given. So there may be some, because of the model conduct or something, so we'll put it up after 3 weeks, let's see what, then what comes up after that. You bring in, after 3 weeks, you bring in your, I mean, latest, this thing, okay, whatever instruction you get. You put their names of both the parties represent their names. Let it be after 3 weeks.
Any date,
Huh?
after 3 weeks, any.
And after 3 weeks, okay.
Any date,
Let them come. No, these dates, no dates. After 3 weeks.
24. The issue was regarding, my lord, issuing of a disability certificate by examining the petitioner.
Yeah, have you done it?
Yes, my information is that my lord, joint director has finally got the report from the GMC, and it is probably above 40, so you will get the benefit. Because 40% is required for the disability certificate.
So
It is
40, that,
It is above 14, lordship may not recorded, but to my knowledge, my lord, whatever I have got.
then how do I dispose it of?
No, that examination, they are submitting that they have been examined. I was directed to have a confirmation.
Whether it's an examined or not.
That part I.
No, earlier there was thinking that there was some,
No, there was a neurologist.
ineligibility on the part of the director, right?
Yes.
Now that.
That part, that's why, my lord, since there is no expert in my lord Dorong,
Hmm.
so it was referred to GMC,
Hmm.
and the report has been now forwarded by GMC to joint director. So he will issue the certificate.
So we'll dispose it of.
It can be disposed of. In fact, on the last vacation, they played that it can be disposed of. I just thought for the clarification pursuant to court order.
You had heard MS, your name?
Doctor.
R. Dr. The learned counsel appearing for the petitioner also heard Mr. B. Gogoi, the learned additional advocate general, Assam, representing the health department. This court, wide its order dated 27/9/2024. Passed in WPC number 45036/2024, directed the respondent number 4, that is the superintendent of Gauhati Medical College and Hospital, Gauhati, to constitute a medical board to examine the petitioner, and if it is found that the petitioner is eligible to be issued a disability certificate, the same be issued. The Mr. Gogoi, the learned additional advocate general Assam, representing the health department, has submitted that the medical board has already been constituted and the petitioner has already been examined. Already been examined. And accordingly, a certificate.
The report has been forwarded to the Joint Director of Health Services, Dorong, who is the competent authority to issue the certificate as per the statute.
He submits, he has submitted what? He submitted that?
That, my lord,
The
the
report-
report of the medical board has
Report
been
of the
forwarded to
medical
the
board has already been forwarded to the,
Joint Director of Health Services, Dorong Mall,
Mongol,
who is the competent authority to issue the certificate.
who is
disability
the
certificate.
competent authority to issue the certificate,
Right.
and accordingly, the same has been issued or not?
It
You
will
not sure.
be issued. It will be issued. That.
And the same will be issued in a short time.
Yes.
Full stop. He submits that, therefore, the order that has been passed in WPC number 5036/2024, dated 27/9/2024, has been duly complied. Full stop. In view of the aforesaid, he submits that nothing survives in the matter and matter can be disposed of, to which the learned counsel appearing for the petitioner doesn't have an objection. So you go and,
Yes.
you go and collect it.
Yes.
So in view of the aforesaid, the instant contempt case, contempt case number 6972024 is disposed of with a direction to the petitioner to approach the joint director,
Dorong.
the
Mo-
joint director Dorong, for receiving the copy of the certificate. Full stop.
Lordship, I'm attending on
The
behalf
matter is disposed of.
Respondent number 1.
You just take her, MS so-and-so is present for respondent number 1.
Decision matter relating to labor code award matter, industrial dispute matter. It may take some time, as we have understand.
It will take
So-
some time, my lord.
So if the lordship take up on another day.
Okay, we'll put it on the first week of May. First week.
Specific date may, lordship.
Okay, on the joint,
Perfect.
parties are duly represented on the joint prayer of the council appearing for the parties, let the matter be fixed on. 5th of April? Oh, sorry, 5th of May,
May.
5th of May,
Of May.
5th of.
May I please, your lordship? May I please, your lordship? Because my senior is on Lakes in code number 3, sir.
Who is the senior?
B. Goswami, lordship.
Lordship, otherwise, Lordship, the issue involved in this petition is, Lordship, only to be considered by this honorable court whether the deputy commissioner has any power or deputy commissioner has been authorized by the any provision of law under the Registration Act to cancel or invalidate any registered sale deed. So far, the judgment of the Lordship, Lordship Satyapal Anand, the Honorable Supreme Court has clearly says that once a document has been registered, thereafter, the district register, in fact, the Inspector General of Register has no power to recall or Lordship cancel that or interfere on that registration cell document, registered document, Lordship. This is a settled position of law. And in this case, Lordship, what happened? Sale deed was registered on Lordship 16/9/2022. And at the time of registration, Lordship, proper stamp duty and proper tax has been paid by the petitioners, Lordship. And in the meantime, Lordship, before, prior to registration, Lordship, the petitioner has applied for, your Lordship may kindly find the impugn order at page number 124.
Okay, you give me the factual stuff.
Thereafter, in the meantime, Lordship, when the petitioner applied for NOC or sale permission for execution of sale deed, at that time, the Registration Act has been amended by the state of Assam under section 21A of the Registration Act. In the said registration, in the said provision, the
Mr. Goswami, this
registration-
can be disposed of today?
Look, in fact, my lord, I had prepared a small list of debts, my lord,
Hmm.
for proper adjudication of the case. my lord. Today,
I will not take much time, Lordship, because the issue is very simple, Lordship, because once the Supreme Court has made numbers of rulings, Lordship, that no one has authority once the document has been registered.
Okay.
Lordship, I have already placed all the judgment of the Honorable Supreme
So
Court.
affidavit has been filed.
Yes, Your Lordship.
You are not filing any reply.
Lordship, I have not filed because the Deputy Commissioner has not taken any other stand. As per the direction of this Honorable Court, Your Lordship may kindly find the.
Mr. Goswami is appearing for who?
DC, my lord. 2, 3, and 4.
So you have filed an affidavit already.
File, yes. Sir.
Deputy Commissioner has filed, Lordship.
Hmm.
There was a direction from this Honorable Court on 10/6/2025. Your Lordship may kindly come to the order dated 10/6/2025.
Yes.
In that order,
Hmm.
the Honorable Court has directed the District Commissioner and come Deputy Registrar to file an affidavit under what provision of law
Hmm.
he acquired and exercise the power to cancel a registered sale deed.
Hmm.
Lordship, in that direction, Lordship, the Deputy Commissioner has filed their affidavit.
What did
And
he say?
The Deputy Commissioner has says that, Lordship, under section 151 of the Lordship Land Revenue Regulation, he has exercised, Lordship.
So what is 115? Let us see what is one. Where is the affidavit? Which page?
Page number 132, Lordship.
132.
Yes, Your Lordship.
Okay, so 132, the stand is that.
Relevant part is 132, Lordship. Page number 132.
Read from paragraph 4,
Yes, Your Lordship.
page 131, please. Read.
That the deponent begs to state that after reviewing the documents submitted by the petitioner along with the statutory provisions governing the matter, it has been observed that the sale deed in
No,
question-
from where you're reading?
Lordship, paragraph 4.
No, you read from the beginning. Paragraph 4 from the beginning.
Yes, I have read from the beginning, Lordship.
Okay. The deponent begs to state.
Yes, Your Lordship. The deponent begs to state that after reviewing the documents
Hmm.
submitted by the
Yes.
petitioner,
Correct.
yeah,
Yes.
uh,
Alongside statutory-
alongside the statutory provisions
Hmm.
governing the matter, it has been observed that the sale deed in question fails to comply with essential legal requirements.
Hmm.
Section 32 of the Guwahati Metropolitan Development Authority Act 1985 explicitly stipulates that no deed transferring land within the Guwahati metropolitan area may be registered without a no objection certificate from GMDA approving the transaction.
Correct.
In this case, the petitioner submitted NOC dated so and so 15/10/2012 pertains only to the construction of an RCC building and does not cover the outright sale of the underlying land. The lack of a valid NOC for land transfer renders the registration of a sale deed non-compliant with the GMDA Act 1985, thereby invalidating its legal validity.
So you basically wanted to, I mean, NOC has been given only for construction.
Lordship, that is true. The
So you tried to take an NOC, not with a clean hand.
no, Lordship.
Then
I have applied for sale permission before the Deputy Commissioner.
you applied for sale permission.
Yes, Your Lordship.
Sale permission of the land.
Land and building.
Hmm?
And in the meantime, Lordship, Your Lordship, kindly.
Let's complete this. Let's complete this. You applied for a land permission.
Yes, sir,
Land
land-
sale permission.
Sale permission.
Correct.
That
And
sale permission,
but NOC has been given only for construction.
no, that is not irrelevant up to this. What the pregab has been quoted by the Deputy Commissioner, that is not relevant.
Okay, just read it. The father. the sole-
Further, the sole GMDA NOC dated 25/10/2025 12 was granted in favor of Sri Rakesh Boyso for construction purpose only. While the land was at the relevant time legally owned by Srimati Lilima Boyso, no duly registered power of attorney or any other document evidencing authority to sell has been produced to justify the same. That after inquiry, it has been found.
So land is owned by Nilima. Who is Nilima Boyso?
Nilima Boyso is one of the petitioner.
Huh?
One of the petitioner, their mother and son.
The mother and son. But it was in the name of Nilima Boyso.
Yes, she's her. That was not a lordship, ancestral or legally inherited property.
No, whose property is this?
It was property she owned by way of purchase.
She owned. So you are
She
right.
sold that property to him.
Who are you? You are Mr.
I am.
You are Nilima Boyso and others only. Okay.
Yes, your lordship.
Correct. Then.
Then, lordship, after inquiry, it has found that the mutation of the said land was carried out in the name of Rakesh Boyso on 10/11/2022, solely based on sale. Solely based on sale deed, number so and so that is 16/9/2022. It was the registered lordship by the district registrar. As this.
So you sold it to, I mean, who sold it? Nilima sold it to Rakesh,
Rakesh.
my son.
Yes, on
Hmm.
16/9/2022.
Hmm.
As the sale deed itself is legally unsustainable, how a deputy commissioner can determine a registered document, he cannot play the rule of a civil court, lordship, because it is barred by the Supreme Court ruling. Legally unsustainable. The mutation carried out on its basis is deemed irregular and may be subject to cancellation by the competent revenue authority. Accordingly, based on inquiry report and legal provisions cited above, the execution and registration of sale deed number so-and-so, serial number so-and-so dated 16/9/2022 is found to be illegal and legally unsustainable. The deed having been executed in contravention of the mandatory legal provisions is declared invalid for registration and transfer of ownership. Consequently, any mutation order passed by the circle officer on the strength of this sale deed is rendered irregular and has been cancelled by so-and-so dated 27/8/2024 as per provision of section 151 of the Assam Land and Revenue Regulation 1886, wherein it is clearly stated that the board, a deputy commissioner, a settlement officer and survey officer may call for the proceeding held by any officer subordinate to it or him and pass such order thereon as it think or he thinks fit. Now, the legal position in this case is that whether.
No, what is 115? Let's see, 151.
151, your lordship.
Land Revenue Regulation, 151.
$151. Power to call.
One second. Yes.
Power to call for proceedings of subordinate officers. The board, a deputy commissioner, a settlement officer, and a survey officer may call for the proceeding held by any officer subordinate to it or him and pass such order thereon as it or he thinks fit. That is not a provision, lordship. It can be exercised in case of any person is aggrieved by any mutation or any lordship partition order that has been passed by the subordinate officer like circle officer or any other officer. But this is not the provision.
But he can call for
the record.
He can call for the proceedings.
Proceedings. There was no proceeding.
They call for the proceedings means proceedings which is going on.
That are going on, but there was no proceeding.
The proceedings which is going on, he can call for it and he can pass a necessary order if he's a superior officer.
But
and superior officer is the board. The board.
A deputy commissioner.
Board. A deputy commissioner.
Deputy commissioner.
A settlement officer. A survey officer. So in your case, who has cancelled it?
Deputy commissioner has cancelled my registered sale deed, lordship. And in this regards, lordship, your lordship may I would like to rely on the Supreme Court ruling whether it can be exercised. I have already, lordship, submitted the judgment of the honorable court before the honorable court with list of judgment, lordship. There is a list of judgment with paragraphs and rules X. It was there in the last occasion I have checked.
Yes.
Now, your lordship may kindly take up the paragraph 13. 13, particularly the Honorable Supreme Court has.
Which case?
Satyapal Anand case.
Paragraph 13.
Paragraph 13. And lordship, the issue decided under D and E. Next page, lordship.
One second. Paragraph 13.
Paragraph 13, close D and E.
Which journal is this?
Lordship, legal lordship. There was, I think, legal there.
Paragraph
Paragraph 13.
13, you can't find out the paragraphs only here.
I have Lordship.
One second, one second, one second. Yes, 13, yes.
13, issue number D and E, your Lordship may kindly see. There was some issues that has been decided by the Honorable Supreme Court. D, whether the sub-register registration has authority to cancel registration of any document, including an extinguishment deed after it is registered. Similarly, whether the Inspector General registration can cancel the registration of extinguishment deed in exercise of power under Section 69 of the Act of 1908. E, whether the sub-register had or no authority to register the extinguishment deed dated so and so, unilaterally present by the respondent society for registration. Now, your Lordship may kindly come to paragraph 21.
Yes.
May I read, Lordship?
Yes, yes.
The rule of sub-register registration stands discharged once the document is registered. Raja Muhammad Amir Ahmed Khan Supra, Section 21 of the Act
Section
of
17.
Section 71 or 17 of the Act of 1908 deals with document which require compulsory registration. Extinguishment deed is one such document referred to in Section 71 or 17(1) subsection B. Section 18 of the Act deals with document registration whereof is optional. Section 20 of the Act deals with the document containing interlineation, blanks, erasures, or alterations. Section 21 provides for description of property and maps or plans, and Section 22 deals with the description of houses and land by reference to government map and survey. There is no express provision in the Act of 1908 which empowers the register to recall such registration. The fact whether
So DC in this case is a register.
yes, registered.
DC is the register or sub-register? He's a
He is
register.
the district register.
He's a register, right?
Yes. The fact whether the document was properly presented for registration cannot be reopened by the register after its registration. The power to cancel the registration is a substantive matter. In absence of any express provision in that behalf, it is not open to assume that the sub-register registration would be competent to cancel the registration of the document in question. Similarly, the power of Inspector General is limited to do superintendence of registration offices and makes rule in that behalf. Even the Inspector General has no power to cancel registration of any document which has already been registered. Now, your Lordship may.
So what is the process of cancellation?
Cancellation can be made only by the by approach. It is also the Lordship there. How it can be cancelled? Supreme Court has decided, discussed in paragraph 25. I would like to rely on that.
25.
Yes. 25. At the same time, may I read at the entire paragraph? Then Andhra Pradesh High Court in the case of Yanala Malesari Supra was called upon to consider whether a person can nullify the sale by executing a registering a cancellation deed, and whether the registering officer like district register and or sub-register appointed by state government is bound to refuse registration when a cancellation deed is presented. The facts remains that if the stipulation continued in Section 70 and 18 of the Act of 1908 are fulfilled, the registering authority is bound to register the document. The registering officer can refuse to register a document only in situation mentioned in section such as 19 to 22, 32, and 35. At the same time, once the document is registered, it is not open to the registering authority to cancel the registration, even if his attention is invited to some irregularity committed during the registration of the document. The aggrieved party can challenge the registration and validity of the document before the civil court. It is not open to the Deputy Commissioner.
Yes.
And this is one judgment. And paragraph 26 is also important. Section 35 of the Act does not confer a quasi-judicial power on the registering authority. The registering officer is expected to reassure that the document to be registered is accompanied by supporting documents. He is not expected to evaluate the title or irregularity in the document as such. The examination to be done by him is incidental to ascertain that there is no violation of the provision of section.
So you are saying that like once it is registered, if it is
cannot be
irregular also, that power is not there with their
Yes.
with the register.
The register. In
Register.
fact, before we did the
So
inspector.
all these case laws are on this. On all these case laws that you have referred.
Yes,
all
all
the-
this, yes. And in fact, Lordship, the judgment, recently Honorable Supreme Court has also decided in the Hemalota, Lordship, Hemalota versus Lordship Takuram. It is in the year of 2021, Lordship. Take up 31.
Hemalata, I mean, from where you have got it?
Lordship, I have print out from the Supreme Court, Lordship, website, Lordship.
Which is Hemalata, the last case.
Yes, paragraph 31.
1 second, 1 second.
In all the judgments, in fact, Lordship, in the Honorable High Court also, Lordship.
How do I find out now, Hemalata? I mean, from this, you have not paginated.
31. Case number 19 here, Lordship. Case number 19.
No, case is on the, you have given a bunch.
8, CL number 8. List of cases, CL number 8. Now, your Lordship may kindly refer to then asset reconstruction
Okay,
company.
I got it now, Yes, which paragraph you said?
Lordship, paragraph 31. For a moment, I will let that.
Yes, 31.
It is a settled position of law that a registered sale deed carries with it a formidable presumption of validity and genuineness. Registration is not a mere procedural formality, but a solemn act that impart high degree of sanctity to the document. Consequently, a court must not lightly or casually declare a registered instrument as a sham, adopting the principle enunciated premising and so and so, Lordship. And these are and also, Lordship, in the case of your Lordship will find asset reconstruction, or Supreme Court has says that, Lordship, only the civil court has this jurisdiction. Paragraph 57, Lordship.
Okay. So that is the only issue, right?
Yes, only this is.
Only issue is that, I mean, it has been cancelled.
Cancelled.
Okay, let us hear the other side.
Yes. My lord, can it be taken up on Tuesday, my lord? His part is over, my lord, will remain part heard, my lord.
Tuesday.
Lordship will take it up
Tuesday I have
for
some
disposal.
difficulty then, Thursday. Today it will not take much time. It can be finished because it has taken up for several times.
No, it's
but
not
the-
happening, keep it here, sir.
In fact, this the
Will
position
remain
is,
as part heard, my lord.
Lordship, the position is very clear. And each and every judgment of the Honorable Supreme
No,
Court has
factually,
made the ruling.
factually, he has not stated the correct state of affairs. I'll apprise your lordship, my lord.
Okay, then Tuesday we'll hear it. I mean, Tuesday is.
Can it be on Wednesday, Lordship? Through Tuesday, I have some fixed matters.
29th,
29.
29th. Okay, heard Mr.
These are my lord.
D. Sharma, the learned counsel for the petitioner. Also heard Mr. B. Goswami, the learned additional advocate general appearing for respondent number
2, 3 and 4.
2, 3 and 4. Assist 2, 3 and 4. 2, 3 and 4. The matter remained part heard. Let the matter be listed on 29th. 29 you have to finish it, otherwise this bench will change again.
29.
29 you have to finish.
Yes, yes. I'll not take
A
much.
small point,
Yes,
yeah,
small point.
small point. We will finish it up.
Highly obliged.
You can take it, this is already there, Sektapal, just give it to him.
Satyapal had to more than.
The Sektapal is already there,
Lordship,
just give it to him. Just give it.
Yes.